mention item number 8, my lord. Because hard on 10th of August, sharing is complete. So you can fix near the date or next week, my lord, as Padhat or as from the list. That it will be disposed of. Also, the Gamsala also hearing of computer on 10th of August.
Who has given the permission? Who has given the permission for listing the matter?
Bench 4, my lord.
Bench 5.
Code number 12, my lord.
Put number 12.
12. Otherwise, my lord, there is so many fixed matter.
So let the matter be listed before port number 12. Why is this matter listed before this court? When no.
I don't know.
Where there is a mention memo. No mention memo upon this. How can there be a mention memo in respect to a hearing matter?
That's the date district, they cannot list it.
Mention memo.
In the senior court, I have to mention the other.
You mentioned it port number 5.
No, my lord. Put somewhere 12, man.
Port number 12 is never taking a bench 5.
We should go to my lord. Port number 5.
Let it be there in port number 5.
Because last court.
Go ahead, port number 5. No, port number 12. Taking into account that a mention has been granted by the court, taking up bench 4, the matter be listed by the registry before bench 4. Then why did you mention it before bench 4? If you mention it before, huh?
There was a bench 4 when the motion of hearing was done. Now, when the recently it is segregated as bench 5, I didn't know about this.
Now, if you have taken that permission, you will let it be listed before that court. But this court is not going to take up. Such permission shouldn't have been granted. Because some matters which are of bench 4, there are lawyers who are mentioning.
After mentioning, I have to know that when the subsidy matter has been graded as matter, bench 5. Earlier it was bench 4 matter.
Yes. U. Chakraborty, appearing on behalf of the petitioner, has instructions to withdraw the instant writ petition. Accordingly, the instant writ petition stands closed on withdrawal. Interim order, if any, stands vacated. Not before me. '53. Mr. K. Bhattacharjee, appearing on behalf of the petitioner, submits that the relief which have been sought for in the writ petition have already been given to the petitioner, and as such, the petitioner would not like to press the instant petition. Accordingly, the writ petition stands closed on withdrawal. I can deliver in view of the order passed in the accompanying writ petition, the instant application also stands closed on withdrawal. Yes. Well, you are paying for a petitioner. Why? We'll see what is there. Oh, that matter. Non-payment. We will look into it. That is a non-payment of dues. You were supposed to file an affidavit on the earlier occasion. Mr. Nath had stated that he has received some instructions and he wants to put it by way of an affidavit. So that is it. Ask him to be there because he has asked for the time and this court has duly fixed it accordingly. No adjournments. Mr. M. Sahewala, the learned counsel appearing on behalf of the petitioner, submits that the relief which have been sought for by the petitioner have already been granted to the petitioner. And as such, the petitioner would not like to press the instant writ petition. Taking into account the above, the instant writ petition therefore stands closed. Interim order, if any, stands vacant. No? 15. Yeah. Let me. At the request of the learned counsel for a petition, a matter stands adjourned to be listed after 6 weeks.
With the consent of the other side, I did for adjournment to pattern number 44. If we are awaiting instruction,
You are for?
I am for the respondent by the respondent number 45.
Have you informed the other side?
But I have a
You have no objection? At the request of the learned counsel appearing on behalf of the respondent, matter stands adjourned to be listed after 6 weeks. Interim order is for what? The interim order passed earlier shall continue. 52? Yes. Hmm? Why? Is a review petition? At the request of the learned counsel appearing on behalf of the review petition, a matter stands adjourned to be listed after 6 weeks. (29)2. What is this matter about? What matter is this? No adjournment if you don't know anything. Next. Yes, it is second file. Huh? We have submitted the affidavit in reply. You have an interim order? Okay. You want to adjourn it? Okay. List the matter after 6 weeks at the request of the learned counsel for the petition.
Item number 20. Item number 2. My senior is sometimes serious. I have medical.
We will look into it. No adjournment of 2014 matters. Yes. So non-payment, you'll get the order. Wait. You want money, this court will pass an order to that effect. Why do you need the adjournment for that? You do it. Yes, Mr. Gulta.
Petitioner and respondent number 7, both are party in relation. There was a family dispute since 2007. The respondent number 7, he tried her all base to areas to disposes the present petitioner from the residential premises as well as the business premises. This is the shared between both the families. And ultimately,
So the petitioner is residing in the residential premises.
one RCC building, both the families are residing in the same complex.
Then
And there is an Assam type house, in that house, both the families are running their families. So, the respondent 7 has been trying her best to dispose the present petitioner by all means. But several cases are filed against the present petitioner, including rape case and all other cases. Ultimately, she, along with 11 women, vandalized the business premises of the present petitioner. And when he informed the concerned police station, he then OC came to the spot, and in his presence, whole the premises had been vandalized and looted, and FIR was lost, he did what he did, he taken away the key of the by locking the business premises, he taken away the key. After 3 days, he handed over the key to the respondent number 7. Without issuing any seizure list, he taken away the key. And now, respondent number 7, thereafter respondent number 7 is running the business. So in that case, civil suit also filed by the present petitioner because which is pending. And now, this petition, particularly this petition, was for the inaction on the part of the respondent number 6, the then police officer. He has been named as personal capacity also, party. And all along he refused to receive the notice from this honorable court. Thereafter, we on the leave of this honorable court, we issued notice to the headquarters. Then also he refused, ultimately deemed to be served by something. So, it is the prayer of the present petitioner before this honorable court. It was an inquiry as to what authority, how he can misuse his official official
how do I know that he has misused? It is your statement against them.
Yes,
Then how can this court decide that?
I have made him party.
Understood, understood, but it is your statement against this. But can this court decide these aspects?
In the FIR, what he did.
Have you filed any complaint before the police, the magistrate?
The complaint was forwarded also to find at page 61. Complaint was immediately thereafter on public complaint, then OC was transferred. Then numerous complaints came before him, complaint was lodged, and his complaint was forwarded to the LTO civil as well as SP Nagaon.
No. This is a complaint filed under this is a complaint petition. What order has been?
61.
This complaint, in this complaint, you have at page 51, you have, what is this complaint at page 51? Where a case has been already done, private visit under 143, 1 has been done.
Yes, what happened in that FIR, instead of causing any inquiry, this respondent number 6 submitted final report. So against that final report, protest petition was filed. This protest petition was registered as this complaint.
Which one?
Here, page 51.
If it is a protest petition, why that respondent number 6 is not a party in the protest petition?
The FIR was initially lodged.
Understood, but have you filed the FIR against the respondent number 6?
No,
Then why would this court, if the otherwise it is an interstate dispute between you and the respondent number 7?
Then the can you see page 61. Because this FIR was prior to handing over the key matter. This 51.
Page 51.
Page 51, arising out.
It's not a FIR, it's a complaint case.
Earlier it was FIR, but when FIR was submitted, petitioner submitted protest petition. That was considered as a complaint.
And then a process was issued. So that it must be pending somewhere, something must have happened. Now, what is this?
The
Hmm.
61, when the key was handed over to the respondent number 6,
Hmm,
by the present, by the detained OC,
hmm,
this complaint was filed before the new income tax,
hmm,
So this complaint was forwarded to the SDO civil as well as the SP Nagaon,
hmm.
but no action.
No, if there is any allegation, why you are not filing a complaint before before the chief judicial magistrate?
Chief Judicial Magistrate, no complaint was.
No, why you have not done it? Because if he has done any illegalities in respect to this, or he has violated any provisions of law, you can very well do it. Now, if it is a case where you want this, is it your case that this notice which was issued on 26/12/2013 should be brought to a logical conclusion? That's all. Nothing more than that, because beyond that, this court cannot go into it.
But, yes,
Yes. Mm.
This 61, after this registration, the respondent number 7 and other 11 women, the 80%.
Let us read page 61. Page 61. Yes.
I have the honor to inform you that I am a resident of Thakurpuri Road, West of West Bengal. That on 23/11/2012 at about 11 AM, Sangeeta Ahuja along with more than 20 women breaking the law of the door of my shop entered into and damaged, destroyed the shop, looted rupees 63,000 cash, and also physically tortured my wife and throughout the articles outside of my shop, and also present the OC Lovely police station with 3 constables at the place of occurrence, and also gathered the local inhabitant and saw the matter and taken photograph also, and then OC Lovely lock the door and take the key in his custody. In this regard, many cases pending before the trial, before the court of justice, one that the miscreant Sangeeta Ahuja recently opened the shop where from they found the key or breaking the lock of the door of the shop, which is closed by OC Lovely at the time of occurrence on 23/11/22. I do not know about it.
Then,
So I therefore pray that you may kindly look after the matter and take necessary action against Sangeeta Ahuja
you are
and
asking
other
that same person. You are asking the same person or different person? Are you asking the same person? Because your allegation out there is page 61 is against the OC. And you are asking the OC to investigate. Why?
Because-
And if it is so, then it would be at best an FIR.
Because, my lord,
And then if it is an FIR, then why you are not approaching under 156(3)?
when the respondent number 7 and others failed their attempt to dispose me,
Hmm.
then they took help from the OC, and OC helped them by handing over the key to them.
So what do you want out here? What is your prayer?
My prayer, my lord,
Your prayer is shall not be issued directing the respondents, more particularly respondent number 2 and 3, to cause an inquiry as to how the respondent number 7 got the key of the shop of the petitioner, which was taken away by the respondent number 6 by locking the shop, with the further direction to the respondent number 5 to evict the illegal trespasser from the shop and to initiate an inquiry against the respondent number 6 for his alleged involvement in the incident with the respondent number 7. Now let us see the affidavit which has been filed.
affidavit filed only by the
Respondent number 3.
yes, my lord.
Let us see paragraph number 9. Paragraph number 8. the then so-and-so himself locked the door and took away the key of the lock, and the petitioner went to the officer in charge on various orders for the key of the lock so that he might what so-and-so, so-and-so, so-and-so. The deponent further states that the same are civil and family matters and all the matters of documents, hence no comment. However, the allegation made against respondent that the respondent occupied the room by criminal force with the aid is for illegal and irrelevant consideration, and the respondent number 6 for illegal and irrelevant, and a man does not have any authority to use his official powers for providing assistance or such as illegal deed and so in pollution, lock the respondent so and so are strongly denied and not admitted, and the respondent number 6 never acted illegally and never acted in collusion with the respondent number 7. Now he says, you say, he said. How does this court determine? Tell me.
Press remains that Malad, he is now operating the firm.
Understood, but for that a civil suit is pending.
Yes, and he has been taken away by the OC Malad.
The fact that the key had been taken out by the OC is a question to be proved before the appropriate authority. They deny that the key had been taken.
And it can be Malad, and the FIR Malad, which was by me, that was Malad within 7 days, that was Malad instead of causing any inquiry, Malad immediately Malad submitted the final report. And ultimately,
So for that you have already gone before the authority concerned.
yes,
So for that the already a proceedings, a criminal proceedings have been initiated against them. So that is already there.
yes.
So now when the key which has anything which has happened thereafter, they have denied to the suspect of the matter, then how does this court pass an order to that effect?
That is true, Malad.
Because your relief, what you are asking is that this court should help you to gather evidence against the respondent number 7. Isn't it?
No,
Yes. Why are you asking for this? You have already filed a suit.
I am just.
You have already filed a criminal case. All these things are going on. Then why are you asking for this relief?
I am only praying for Malad, only an inquiry against the Malad, number 6, nothing more, Malad. If Malad inquiry caused by his father, nothing, but then it's okay, Malad. But Malad, they are causing nothing, Malad. I have submitted complaint, Malad. So in front of the officer.
You have submitted. Why haven't you approached the SP?
SP, Malad.
No, that is it is more like an FIR. Why have you issued it to the OC? You have not asked for an inquiry in your that particular communication.
Malad,
Have you asked for an inquiry against that then OC? No.
I pray that you may kindly look up that matter
So
and to take necessary action.
then why you have not asked the authorities concerned, and why you are approaching this court then? If you are only into the inquiry,
Yes, Malad.
then
And other person involved.
when there is a civil suit, there is a criminal proceedings, everything is pending. You want to file something, or you will obviously you should have filed an FIR against that person concerned or a complaint to that effect. Now, your basic thing is to gather it back. If there is a theft of this 3,96,000 which you are stating out there in your petition, then it is a case of theft. Then why not you are approaching? Have you mentioned all these things in your complaint?
Respondent number 7 from 2007, all along they are trying to dispose it. When they fail to do so, they could help from the state and OC, and somehow they could succeed in their manner.
So therefore, you should have initially proceeded and filed the suit. Initially, not to disturb your possession. You have not done that. But this court cannot be made a tool for to gather your evidence. Yes, Mr. Talukdar, what have you done?
Our case is the complete different.
Where is that respondent number 6 working now?
Our case is transferred. Was transferred.
That means you have your people do not know anything about.
After
You have not inquired with him.
this was by the 2014.
Now, how did you gather your information and giving a denial of the entire thing without taking information from the respondent number 6?
Ask them with some, but
So if that is so, produce it.
I do not know. It is not there.
No, because you are saying on affidavit. Who is saying on affidavit that 1 to 15 is true to your knowledge? How can he say on true to your knowledge about that particular thing when he was not present in the site? Unless he have made the inquiry with him. And you don't know where he is. So this person concerned who has filed, the superintendent of police, Nagaon, he has filed this affidavit without actually knowing the fact. Eh? How can you do so? So your affidavit is false. Where is this person working now? Aravinda Kolita. Yes, who is paying for whom? You are paying for? Yes. What is going on? No, we are going to take it that you admit what he's saying on the ground of non-traverse.
Case was value for steps for quite a long time. Otherwise, you could say down disputed facts. If he has any because there is a public.
I don't think you have any problem with regard to the inquiry to be called against the respondent number 6. No, rest, this court is not going to do it. As regards the respondent number 6, you have no problem. Mr. Talukdar, do you have any problem, objection? If there is a direction to the DGP for the causing an inquiry as regards the respondent number 6. That is the only thing you want. The instant petition has been filed by the petitioner, seeking various reliefs, including the relief that an inquiry be caused against the respondent number 6, who was then the officer in charge of Lamding police station. From a perusal of the materials on record, it reveals that the petitioner claims that he was running a grocery shop
Huh?
a stationery shop where in an stationery shop in the name and style of MS Ahuja Traders. It has been alleged by the petitioner that the respondent number 7 have been all along trying to dispossess the petitioner from his shop. And having not been able to do so, took the help of the respondent number 6, who was that then officer in charge of the Lamding police station. It has been alleged by the petitioner that on the basis of the said, that in collusion with the respondent number 6, the respondent number 7 was able to dispossess the petitioner. It has also been alleged that the respondent number 6 took the key of the business premises of the petitioner without any seizure list. And later on, it could be seen that the respondent number 7 had opened the said business premises and was running the said stationery shop, which was the business premises of the petitioner. It is further apparent from a perusal of the writ petition that there is a civil suit which has been filed by the petitioner against the respondent number 7, as well as a criminal proceedings have also been initiated against the respondent number 7 and many others, which have been registered as CR case number, complaint case number 27, registered as CR case number 27/2013, and was pending before, and the learned SDGM Hosai Sankardev Nagar had issued process under section 143/447/448/379/323/506 of the Indian Penal Code. Taking into account that the litigation between the petitioner and the respondent number 7 are pending adjudication before the civil court as well as in the criminal court, this court would not like to comment on the same, as it may prejudice either of the parties. Be that as it may, there is a serious allegation being made that the respondent number 7 had resorted to, was able to dispossess the petitioner with the help of the respondent number 6, who was the then officer in charge of the Lamding police station. A representation was submitted on 26/12/2013 before the officers in charge of the Lamding police station, who was the incumbent after the respondent number 6. And copies of the same were also sent to the SP Nagaon, the SDO Civil Sankardev Nagar, as well as the DC, as well as the and so on. SP Nagaon. It is the case of the petitioner that no action was taken on the basis of the said complaint. It further reveals for the records that this court had issued notice by an order dated 28/5/2014 the SP, the Superintendent of Police Nagaon, pursuant thereto, had filed an affidavit on 2/8/2014. From a perusal of the said affidavit, it reveals that there has been complete denial to the case of the petitioner. And it has been also mentioned that the respondent number 6 were nowhere involved. In the taking over the key, as well as handing over the key to the respondent, taking over the key from the petitioner and handing over the key to the respondent number 7. This goes further. It is also relevant to take note of that the said affidavit has been filed that in the said affidavit, the Superintendent of Police Nagaon had made the statements therein on the basis as true to his knowledge. This clearly shows that there was no investigation or inquiry being carried upon the respondent number 6. on the allegations were made against the respondent number 6. Considering the above, this court therefore. Next. This court have duly heard the learned counsels for the parties. The allegations which have been made against the respondent number 6 is a serious allegation as regards the abuse of powers conferred upon him when he was the officer in charge of the Lamding police station. If there's any iota of truth on the said allegation, such allegation, appropriate action has to be taken by the police administration against the respondent number 6. It is also seen that in spite of receipt of the notice, the respondent number 6 have chosen not to reply. Taking into account the seriousness of the allegations, it is also the opinion of this court that the police administration, more particularly, the police administration of the government of Assam, and more particularly, and at least the SP Nagaon ought to have inquired into the matter. This aspect, however, seems to have not been done by the respondent authorities, more particularly taking into account that there is nothing mentioned in the affidavit filed by the respondent number 3, as well as also from the affidavit itself, it transpired that the respondent number 3 had stated everything from his knowledge. This court further finds it relevant to observe herein as to how the respondent number 3 could have stated in his affidavit about certain facts when he was not present in the court, present in the place of occurrence, as true to his knowledge. Be that as it may, this court finds it relevant that such allegations which have been made against the respondent number 6 needs to be inquired into by the police administration of the government of Assam. Under such circumstances, the petitioner grants the liberty and directs the whom? SP? The superintendent of police, Nagaon. No, not him. Somebody else. I think the post is still there.
Some high officers.
Whom? The IG administration, Inspector General Administration. Of the government of Assam to inquire into the allegations made against the respondent number 6, that is Sri Bhavani Dhar Sharma, who was then the officer in charge of Lamding police station. The said inquiry be concluded within a period of 3 months from the date a certified copy of the instant order is served upon the Inspector General of Police Administration by the Government of Assam by the petitioner. The petitioner would also be at liberty to place such other additional facts or materials by way of a representation.
Name of the software instead of Ahuja Trader, it should be Messrs. Vikas Kumar Ahuja.
You have mentioned as Ahuja Traders.
That is the reference number 6.
Where is it named as Vikas Kumar here? Where is it?
Why that is 8 madam? Paragraph 8 madam. Sorry, madam. Page 7. Page 7. The petitioner was writing the both the business that is Messrs. Ahuja Cocoa Center and Messrs. Vikas Kumar Ahuja. After opening, he opened the school method. After that, Cocoa Center closed method and he is running Vikas Kumar Ahuja.
MS Vikas Kumar Ahuja boli koyi, huh?
Right.
So this, it is made clear that the above observations so made shall not affect the proceedings pending between the petitioner and the respondent number 7 before the civil court as well as before the criminal courts.
Hello to
Yes. What is the case? Yes. You are not interested in the matter.
no. My senior is suffering from serious. He's suffering from gastric ulcer.
At the request of the learned counsel for the petitioner. At the request, Mr.
P.J. Brahma.
P.J. Brahma, the learned counsel has submitted that the counsel representing the petitioner is suffering from serious illness and as such is not in a position to appear before this court. Taking into account the above, this is the matter after the puja vacations.
Number 3.
Yes, none appears. No, I have seen it. None appears on behalf of the petition on call. It is seen that the petitioners have not appeared on various dates, that is on 17/9/2018, 16/9/2019, 6/11/2019, 12/6/2020, as well as on 13/12/2021. It seems that the petitioner is not interested with the instant proceedings. Taking into account the above, the instant proceedings stands dismissed for non-prosecution. It is further directed, taking into account that the main writ petition, the accompanying writ petition had been dismissed for non-prosecution. The interim order dated 23/12/2015 passed in IA 2856/2015 also stands vacated. The said application is also dismissed for non-prosecution.
And number 6,
So I দিব না mean at I. Yes, what is it?
we are currently in order that you got find at case 25.
Page 25. What are you challenging? Directing the respondent not to give effect to the order dated issued by Iman and also direct the respondents to allow the petitioner Raji's business through the damp room in terms with the agreement dated so and so. Yes, which order?
Case 25.
25. Seen the report submitted by the superintendent of police and in charge of this so and so. As per the report of the police, it has come to me that so and so had given a room on monthly rent basis to run his business for 11 months since the date of execution. The state tenancy was liquidated in a month. But child refused which this may have been offered at the rent. Then what happened? You gotta stay.
Yes.
Huh? Then what happened? Who is paying for whom? What about the respondents, private respondents? Are they appearing? Service is complete. We set aside this. They have no business out there. It's a private dispute. The police shouldn't have been doing. What is wrong with your police? Today I'm getting one case of police doing that, and this is another case of police. The police should. You have a particular circular that the police should not do anything in respect to civil matters. Don't you have it? Huh? What does it say? You have rightly done it. Huh? If it is a civil dispute, then why? What is the business of him to issue this order? Under what power he has exercised this power? Under 145. This is being done by whom? Additional Deputy Commissioner. Yes. And where is the initiation of his proceedings? This is an order of attachment under 145 or 146, isn't it? This is an order under 146. Where's the order? 146 or 145? Where's the order by which he has initiated proceedings under 145? And what happened there? Huh? As per the powers conferred upon me by 144, 133, 107, and he attaches. Pass an order to seal the dam. Oh, goodness. Now, the instant petition has been filed by the petitioner. And it is now, you are operating out there. The instant petition has been filed by the petitioner challenging the order dated 2/3/2017 passed by the additional Deputy Commissioner Jorhat, whereby the room which the petitioner had taken on as a tenant was attached was put under attachment by sealing the same room. A perusal of the said order reveals a perusal of the impugned order dated 2/3/2017 on the face of it reveals that it is a dispute of landlord and tenant between the petitioner and the private respondents. As it is this court cannot also be unmindful that this court at this stage finds it relevant to take note of that the provisions of Section 5 of the Assam Urban Area Rent Control Act 1972 duly applies. The respondents, instead of approaching the court seeking eviction of the petition from the tenanted premises, had taken recourse to a proceedings before the additional Deputy Commissioner Jorhat, and who, by the impugned order dated 2/3/2017, sealed the room, the tenanted premises, in purported exercise of the powers under Section 144/133/107 CRPC. In the opinion of this court, the said order on the face of it amounts to abuse of the process of the court, abuse of the powers conferred upon the additional Deputy Commissioner Jorhat. When the petitioner and as such, the impugned order dated 2/3/2017 stands set aside and quashed. With the above, the instant petition stands disposed.
7.
Yes, what is this?
It's not sharing the society, they are in opposition of physical land out of minor proceeding of the. It was initially getting reserved, but later on it was reserved. Now petitioner is on possession of only 60 bigger in draft number 354. The subdivisional land development land advisory committee already accorded approval for development of the 60 bigger land in the name of the petitioner society. But till that, the amendment has not been issued. This grade is 18. And except 3, the term may not receive everything in front of us.
Huh? How did you de-reserve a reserve grazing ground?
That is for the purpose of that is for ex-ordinance society. For them, that was done. But there are certain other anomalies. Out of 60 vehicles, sorry, it says whether the petitioner society who is really comprised of 31 members. Out of
You see, no, very well. The fact that you have not till now decided, you want to decide?
Fine.
Decide it. 3 months.
Fine.
That is the only thing why you have come.
Yes,
I can't direct them to allot these 60 bighas to you. No, I can't direct. I can only direct them to consider.
As per the resolution taken by the land allotment advisory board.
It is done, that was done in 1991.
Yes, madam.
Then what right do you have on the basis thereof?
Both for the not to take any course for the action, they have been affected from one part. There is two part, madam.
Are you in possession
Yes, madam.
of
We are in
60
possession.
bighas?
60 figure. No, I did. No, we are in possession, madam. They are in. They are forcefully evicted these.
Okay, very well.
from
You are
30%.
saying no possession, he is saying, you are saying in possession, he is saying in no possession. The direct status quo till the applications are disposed.
Yes, madam.
That is it.
Already, the honorable court has directed not to take any course action.
That was done then.
Yes, 2020.
Very well. So we will pass an order now. Not, because this can't remain like this. Your allotment application has to be disposed of by them
Yes,
within 3 months. That is your prayer. The petitioner herein is aggrieved by the non-consideration of the application for allotment of land of 60 bighas under Dag number 354 at Lalunggaon, Kisamot, under Botodrova Moza, Nagaon, to the petitioner's society pursuant to the approval granted in resolution number 141 dated 3/4/1991 by the Subdivisional Land Advisory Committee, Nagaon. The record reveals that the petitioner society society of what? Huh? The petitioner record reveals that the petitioner society is a society of 29 members. 29.
Yes.
Dealing with 29 members engaged in the business of agriculture. They're carrying out their livelihood on the basis of agriculture. The members of the petitioner society have been in occupation of lands at measuring 60 bighas by constructing dwelling houses. It is relevant to mention that the said 60 bighas of land is in Dag number 354, situated at Lalunggaon, Botodrova Moza in the district of Nagaon, Assam. The said Dag, being Dag number 354, contains, as per the petitioner, 264 bighas, which was a Marsi grazing reserve land. In the year 1988, the government de-reserved the 264 bighas of land for rehabilitation of ex-army men and the landless cultivators. The petitioner thereupon duly applied for 60 bighas of land The Nagaon Subdivisional Land Advisory Committee, by resolution number 99 dated 12/9/1999, had approved allotment of 260 vigas of land under DAG number 354 to the members of Khanti Soinik Milan Committee, out of which 60 vigas of land under the possession of the petitioner society. It is further apparent from the perusal of the writ petition that the Subdivisional Land Advisory Committee, District Nagaon, had accorded the resolution being 141 dated 3/4/1991, wherein "60 vigas of land was approved to be allotted and was recommended to be allotted in favor of the petitioner society." However, it is also seen from the records that on 8/7/2003, the collector cum deputy commissioner Nagaon had directed the petitioner society to pay revenue in respect of 60 vigas of land under the possession of the petitioner. The petitioner thereupon claims to have paid the said revenue. It is further seen that the petitioner thereupon have been approaching the respondent authorities for granting the allotment pursuant to the recommendation made by the Subdivisional Land Advisory Committee. But the respondents have not taken any steps for which the instant writ petition has been filed. It is also the case of the petitioners that on one hand, the allotment which the petitioner, on one hand, the respondents have not issued the allotment order, but on the other hand, the respondent authorities were trying to evict the petitioners. This writ petition was filed on 3/4/2017. And by an order dated 6/4/2017, this court had issued notice. It reveals further from the records that on 11/11/2022, an application was filed by the petitioners seeking a direction upon the respondents not to disturb or evict the petitioners from the peaceful possession and occupation of land of 60 vigas under DAG number 354 of Lalungaon, Moza Botodrova, Nagaon. This application was registered and numbered as IA Civil number 3306 of 2022. This court, by an order dated 15/11/2022, directed that no course of action should be taken by the state respondents for evicting the applicants from the land under their possession. I've heard the learned counsel. It is further relevant to take note of that even after a passage of around 6 years, the respondent authorities have not cared to file any affidavit. Let me come there. I have not come till now. And this aspect of the matter was also duly noted by this court on 26/4/2023. In spite of the order passed on 26/4/2023, whereby the Revenue Department of the Government of Assam was directed to file the affidavit within 4 weeks, the said affidavit have not been filed. Today, when the matter has been taken up, Mr. A. Bhattacharjee, the learned counsel appearing on behalf of the Revenue Department, have placed a set of instructions issued by the Additional Deputy Commissioner, Revenue, Nagaon. In the same instructions, it has been mentioned that the petitioners' society originally comprised of 31 members. Out of these 31 members, 17 members are not landless and have land in their father's name. At present, only 9 members have been possessing and residing in the said plot of land by constructing dwelling houses. Out of these 9 members, 4 members have land in their father's name. So only 5 members who have possession and residing in the said land are found landless. This is based upon a report from the circle officer dated 23/5/2023 and 3/3/2021. It was further mentioned that the disputed land measuring 60 bighas covered by 60 bighas. Some of the petitioners are in possession as encroachers, and it was not allotted to the petitioner society as per the Chita copy available at the Dhing Revenue Circle. Further to that, it was mentioned that the minutes of the Subdivisional Land Advisory Committee meeting dated 25/4/1991 submitted by the petitioner could not be traced out in this office. Be that as it may, the said minutes furnished by the petitioners have been examined in the office. In the said minutes, the name of the petitioner society appeared 2 times in the said minutes. Number 1, at the resolution number 99, where the allotment was not approved, and number 2, Roman 2, at the resolution number 141, where it was approved. It was mentioned that in a subdivisional land advisory committee sitting does not draw 2 resolutions for the same allotment proposal. It was further mentioned that the font size of page 2 and 3 is different from the font size of page 1 and 4. It was alleged that it was alleged that page 2 and 3 were manufactured. Further to that, it was mentioned that the land revenue alleged to have been paid by the petitioner was nothing but an encroachment penalty, as the land in question is a government land. And this aspect of the matter have been approved by the Muzada Botodraba. I've heard the said instructions so submitted by Mr. A. Bhattacharjee is kept on record and marked with the letter, said instructions, along with the documents enclosed therewith, are kept on record and marked with the letter X. I've heard the learned counsels for the parties and perused the materials on record. The fact that the petitioners have made applications seeking allotment and the petitioners claim that there is a recommendation made by the Subdivisional Land Advisory Committee to recommend the 60 acres of land in favor of the petitioner has to be brought to a logical conclusion by the respondent authorities, and more particularly by the Deputy Commissioner Nagaon. In consultation with the Revenue Department of the Government of Assam. This court further finds it relevant at this stage to take note of the provisions that recently, that in the year 2019, the government of Assam had come up with a new land policy, which is presently in force. Mr. Counsel, you do one thing, you file applications. Under such circumstances, if any allotment has to be made in favor of the petitioner society or its members, the same has to be done in terms with the land policy of 2019. This court, therefore, grants the liberty to the petitioners herein to file fresh applications under the land policy of 2019, seeking allotment of the lands. And upon such applications being filed, the Deputy Commissioner Nagaon, as well as in consultation, as well as the Revenue Department of the Government of Assam, shall take necessary decision as regards the entitlement of the petitioners in respect to such application, in respect to allotment as sought for. This court further finds it relevant to take note of that the petitioners have an apprehension that they may be evicted by the respondent authorities in the meantime. This court therefore grants the liberty to the petitioners to file their application within a period of 30 days from today. And if such application is filed within a period of 30 days from today before the Deputy Commissioner, Nagaon, the possession of the petitioner shall not be disturbed. The status quo as on today shall be maintained in respect to the lands in question till the disposal of the application by the Deputy Commissioner Nagaon in consultation with the Revenue Department of the Government of Assam. It is, however, clarified that if such application is not filed within the 30 days, as mentioned herein, as stipulated herein, the benefit of the interim order not to disturb, to maintain status quo shall not apply. With the above, the instant petition stands disposed. I only dispose it.
Right. Standard, madam, we're taking approach from the madam. Environment clearance, madam, giving much trouble.
What remains here?
There is a instructions and there is a circular, madam, which says, madam, all beyond 5 hectares cannot be set.
No, nothing remains here.
Even they have also not madam, questioned, I come from madam, they have not questioned further.
Taking into account that the period of a short tender notice dated 17/3/2017 is already over in the month of April 2022. Nothing remains to be adjudicated in the instant proceedings. Accordingly, the instant petition, therefore, being infructuous, stands closed. The interim order, so passed, stands also vacated.
9.
This order could have been passed in 2022 only. Yes, Mr. Mahmood. Mr. Mahmood, in this excise matter, what are you doing in an excise matter? That too a wine shop.
Two orders. The order, the reporting in the cover, whether my learned friend has got it or not.
Shall not be issued direct.
It's running my, in his shop is much outside, my inside. Everything is okay, reporting in the server. So in that, there was a complaint laws against the matter, that because it was decisions against the decisions, but the court agreed, but it's far away.
Where is the 4/6? You are who? Who are you? In view of the public complaint, the shifting order for IMFL off license of so and so to new located site located at ward number so and so at the rented so and so is kept in abeyance until further orders. So now what remains?
Now that impact the matter, found everything correct. So, solid shifted and it is running, and the report is also in that order. That order was passed without hearing you, that's why the matter was found in the knowledge of that is.
The instant writ petition was filed by the petitioner challenging the order dated 4/6/2017 issued by the Deputy Commissioner Honipur at Tezpur, and also for a direction to allow the petitioner to run his IMFL off license that is MS Dhakiazoli Wine Shop at Ward number 7, holding number 155, at the rented house of Mrs. Runumi Devi. It reveals from the records that pursuant to the filing of the instant writ petition, this court, by an order dated 9/6/2017, issued notice and provide and directed in the interim that the operation of the petitioner's wine shop shall not be disturbed until the returnable date. The said interim order was passed on the basis that the petitioner had already started operating his wine shop with effect from 3/6/2017 and prior to the issuance of the impugned order dated 4/6/2017. A perusal of the writ petition next. A perusal of the writ petition reveals that the wine shop of the petitioner is situated as per the extent, as per the Assam, in terms with the Assam Excise Act 2000 and the rules framed therein under. And the issuance of the impugned order dated 4/6 and the impugned order dated 4/6/2017 was passed in complete violation to the principles of natural justice. Be that as it may, today when the matter has been taken up, Mr. D. Gogoi, the learned counsel, standing counsel for the Excise Department, had submitted that an inquiry was conducted pursuant to the filing of the writ petition. And from the inquiry, it was found that the wine shop of the petitioner was approximately 700 meters from the educational institution, which fulfills the rule 289(2) of the Assam Excise Rules 2016. And also the NOC received from the chairman of Dhakiazoli Municipality Board, which fulfills Rule 295(1) of the Assam Excise Rules 2016. It was also mentioned in the report that excise guidelines, including the SC distance means and the Supreme Court distance criteria, was also fulfilled by the petitioner's wine shop. The said report submitted, the said inquiry report was submitted by the Inspector of Excise Dhakiazoli Circle on 15/6/2017 and was placed before this court during the course of hearing. The same is kept on record and marked with the letter X. So, taking into account that the petitioner's wine shop which is Runumi Devi, covered by tag number 287 and included in PP number 149 in the district of Punitpur, Assam, cannot be said to be in violation to the provisions of the Assam Excise Act 2000 and the rules framed therein under. Accordingly, the impugned order dated 4/6/2017 is set aside and quashed. Anything else? With the above observations and directions, the petition stands disposed. Yes, Mr. Advocate, there's no, is this anything to do with? Oh, that matter, garbage. Yes,
That's also slow, my lord, technical matter, maybe, my lord. Not in the record, my lord, that's too slow, my lord, for your lord.
yes.
Last page, my lord, that page 47. On the top, my lord, we have marked by page, my lord. And then, in between the land and the garbage station, there is a pipeline, my lord. There is some spaces there, and immediately after the garbage station is the highway.
Where?
On the top, I have.
There's pipeline.
Yes, that is.
Where's the garbage?
That I have marked with pale line.
Oh, that was small one.
Yeah,
Beyond the pipeline.
beyond the pipeline.
And your property is
Yes,
on the backside.
immediately after the pipeline.
So it is good. They have done it. They have not disturbed you. From here, it is clear there is a pipeline in between.
Pipeline is there.
Then anybody can at any point of time keep on asking that this will be near my place and all. Where will they have the garbage station?
My lord.
They are not processing the garbage there. They are only collecting.
My lord,
The collection is
immediately it is clear to. My lord, and we go by the highway, my lord, by the road, main Getty road, my lord. It falls in between my place and Getty, that's it, my lord.
but there is a pipeline in between.
Yeah, it is there, my lord, but my land is also quite big enough. So
Your land is on the backside.
that side, but my lord, when we go by the Getty road, my lord, if the garbage station comes first, then our land. So it is, that is one point, my lord. And second, my lord, since we are, yes, I will, humble it, my lord. We are contemplating to put up some residential structures, my lord, like, then there is again a question of all that other, my lord. Yes,
Is that for what?
yes,
No, whatever may be, these hazards, whenever a person or the GMC wants to put something as garbage center or not, there will be some guidelines.
I have gone through it, my lord. The guidelines are not very clear, my lord. That is one aspect. Let me go through it, my lord, because I have found some, but only the authority has been given the DM to find other place, my lord, but the criteria for that, I have not, because this is guided by that solid management of waste, my lord, up to 2016 rules. That is one aspect, my lord.
You are still running it
Running it.
because I have asked you, I have permitted you to.
So can it be, my lord, after the session, well, then-
No problem, we can have it after 10 years.
No, my lord, we had my lord, another aspect, my lord, can it be, my lord has asked the authorities, my lord, to find out whether there would be any place where this can be transferred. That was one.
Now,
question.
first of all, this will arise if there is a violation of something. From this map, it is seen that there is an oil pipeline, and the oil pipeline, this is the main oil pipeline,
Yes.
which I remember.
It is-
There is a huge pipeline for that. And this oil pipeline belongs to the oil.
Oil.
And beyond that is your land.
beyond that line.
So unless there is an infraction by any act or rules, can this court?
There was a rule, my lord.
Yeah.
Yeah. Because say the 200 meters, some specifications were there.
Or even garbage collection center?
Yes, yes.
Where is it?
Well, I have that, but now. The new, the Environment Protection Act when I come, my lord, that was not there, but here, is there some specifications, my lord?
Now, Mr. Hazarika, you just find out another thing.
That, my lord, which is said, my lord.
That if- You see, we have two types of environment impact assessment notifications. The first was of the year 1994. The second one came in the year 2004 or 2001 or 2004 something. And this has been modified, keeps on modifying every time. Now, this environment impact assessment even applies to the government bodies. So if they want to do something out there, they have to take certain permissions. Now, whether this garbage collection center could be held without an environment impact assessment?
True, my lord, that is. Yes. My lord.
Or is it, am I saying or?
This was. That is a landfill site. But landfill site, my lord, I understand. It is in the petrol and well out in the climate. This is also a landfill site.
This is near that new district judiciary.
Yes.
Land, that land near Boragaon, Posim Boragaon.
Landfill site.
That is another land.
Small one. It has some specification about 100 meters. It has to be,
So
but I
that is
just find
that
out-
land.
I just find out in aspect of this garbage.
And
station.
how much is it going to affect you? Means,
Yeah.
how much is the pollution which is going to affect you?
That part I will check.
We are concerned about the environmental hazards.
Yeah.
And you also see as to whether from whether it is required. There are two. That is why I'm saying one was of the 1994. So 1994 was taken over by 2002. I remember correctly, it must be some 14/7/2002 or something. And this has been kept on modified. Wherein it says when you require an environment impact assessment, whether it is required or not.
That I will.
And you need to then have to research that here it is required, then every time it is changing, meaning more and more industries were brought in. And it will also include if these are hazardous, these will also be there. So prior to setting it up, whether they have taken the environmental impact assessment. And if that is not there, then the pollution control board has to step in. Yes, who are you? Who is pollution?
My lord, I have also heard that, my lord.
Have you made the pollution control board a
No.
party? How can you go ahead with this petition without making the pollution control board a party? They are the main people. See, Mr. Bora has just jumped in. Another party. Who is going to decide? This court can direct the pollution control board to make a verification, check it out as to whether it will cause hazardous or not. Then only your thing can happen. Otherwise, you don't have a case. You have not done anything. In future, we are going to have a particular age. And in future, when you are doing it, how do we know? So let us have it after 15 years. 15 years?
My for this only we are waiting.
For which?
For this. First we have to apply to get it.
They are not going to give you the permission. Mr. Vora appears for GMC and GMD also. And he will ensure that you don't get the permission for this. Then you fight the litigation for another 10 years. Huh? But you have to, but Mr. Hazarika, all said and done, you have to improve your case. These pleadings are not sufficient. You have to show that how are you going, not only you are going to affect it, that you are proposing to do something, then only you are being affected. As of now, you are having a plot of land backside. How do we know it is with tin shades? Some caretaker must be residing out there.
Otherwise, that can. What is your use one? Use one. Okay. That's what we can do. People. What we can do. Use one.
No. Till where he would live? That is another question. No? Patta land, it is okay, but then also, how is it affected? Whether collection center, how much pollution has been caused by them? No, you cannot, unless you make the pollution control board a party. File an application. Please to matter after puja vacations. 11.
And there is no public fund in the official record. So the line is that in regards to civil
We have to remove obstruction caused by the private respondent number 5 and restrain the witness from causing nuisance in the middle of the road, and why this permission will not be like to acquire the land, measuring of swings of the right to. Why they are in occupation? Respond number 1, 2, and 3 are in occupation of the land. Then-
public park.
So, first of all, your case is against respond number 5, who is a private. Why should this court entertain 2 to 6? Second, they have not occupied your land. 1, 2, and 3. Have they? Then why will they acquire? They don't want it. Can this court direct them kindly acquire it? Okay. The civil dispute, I think you need to settle. The instant petition has been filed by the petitioner seeking a direction. Upon the respond number 2 and 3 to remove the obstructions caused by the private respondent number 5 and restrain the respondent number 5 from causing nuisance in the middle of the road, as well as seeking a direction upon the respondent number 1, 2, and 3 to acquire the land measuring 425 feet into 10 feet of Dag number 203 of KP Patta number 139 of village Purna, Doisapara, under Mozapur Bangbag, PS Gograpur, in the district of Nalbari, Assam, under the provisions of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, and Resettlement Act 2013. Madam, is this land yours? From the perusal of the writ petition, it transpires that it is an interstate dispute between the petitioner and the respondent, private respondent number 5. Under such circumstances, the question of issuing a direction upon the respondent number 2 and 3 to intermeddle with the dispute between the petitioner and the respondent number 5 does not arise. Further to that, now, this court further made an inquiry with Mr. N. Goswami, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3, as to whether the land is in occupation of the respondent number 1, 2, and 3. The learned counsel submitted that the land is not in occupation of the respondent numbers 1, 2, and 3, and as to whether the land land which have been sought for which direction have been sought for acquisition is in occupation of the respondent number 1, 2, and 3. The learned counsel submitted that the respondent number 1, 2, and 3 have not occupied the said land. And there is no instruction as to whether the respondent number 1, 2, and 3 requires the said land. Under such circumstances, the question of issuance of a mandamus does not arise upon the respondent numbers 1, 2, and 3 to acquire the land measuring 425 feet into 10 feet of Dag number 203 of KP Patta number 139 of village Punna Doisaipara under Moza Pub Banba in the district of Nalbari. In that view of the matter, the instant petition is devoid of any merits for which the state stands dismissed. Before concluding, this court finds it relevant to observe that the dispute, from a perusal of the writ petition, it reveals that the dispute is a private civil dispute between the petitioner and the respondent number 5. The petitioner would be well advised to file the learned counsel for the petitioner. Under such circumstances, the petitioner would be at liberty to prepare appropriate proceedings before the competent civil court against the respondent number 5. And the dismissal of the instant petition shall not prejudice the petitioner in such proceedings if so initiated. Interim order is there. No. Yes, Mr. Agarwal, what are you challenging? What notice?
Annexure 1, page 19.
Annexure 1, page 19. Notice so and so, respectively, demanding payment of penalty of rupees 2 lakh as an outstanding government dues from the prisoner when the imposed on so and so as personal liability. Yes. Page.
Thereafter,
Now you are challenging which notice? 28/3/2018. Annexure 2.
By the respondent authority.
Huh?
First notice was issued on the petitioner by the Annexure 1, 6/3/2018. Thereafter, another notice was issued on 28/3/2018, demanding rupees 2,50,000 also from the petitioner Shubham Taliwal. And
Why it is perverse?
Lordship, actually, in the order, Lordship, there was personal liability of one Mr. Anu Kumar Singh was there under section 114 of the Custom Act. Let me kindly put it, Lordship, at page 37, Lordship. Annexure 5.
Wait. This is in pursuance to this order in original.
The order fact, the petitioner is the employee of Shubham Taliwal. There was a illegal appointment from the C, and thereafter final order was passed, imposing penalty on 2%.
Where?
So,
Page 29.
Page 23 is the original order. But
Yes.
there is no order.
Huh?
There were 2 orders. There were 2 consignments, there were 2 orders. Page 29 is, page 23 is what?
Page 29 imposes a penalty upon
Another order. There were 2 consignments. Page 37. It is 1,50,000 was default from the employee of the petitioner. Page 27.
I order absolute confiscation of 4 tablets valued at so and so. I impose rupees 4 lakhs on Robert Malaswamy under section 114 for the reasons discussed. I impose 1,50,000 on Sri Anu Kumar Singh under section 114. Yes, then,
Next two orders, thereafter notice were issued.
now where's the second order?
Second order is page 29.
35.
29. Yes, sir.
That is another 1 lakh.
Yes, sir.
And these 3 lakhs have been imposed upon, earlier was to Malsawana under section 114, and here to Life Care, another 3 lakhs. And this to Anu Kumar Singh, 115 and 1,50,000. Yes.
After notice were issued, he didn't pay. Then the department issued notice to his employer.
Why?
Uh,
Can you impose it upon the employer? Was this his personal liability?
Actually, I think some investigation committed because he was the employee of.
No. Is there any findings that it is that company who have done it? Where is the finding?
Page 24A, paragraph 2. Different is that 77 total insurance, 300%. How get to become demand?
Sent from Dehradun to Iman through their transport agency, and the said goods were unloaded in the Iman. The same items. And how is the finding arrived at? As to why he was paid?
Page 27.
It appeared na page 25.
Page 25.
Here, page paragraph 12. Does it appear that so and so purchased the seized so and so containing pseudoephedrine with an intention to export the same illegally to Myanmar, which he knew or had reasons to believe that the liable for confiscation under so and so, and thereby rendering himself liable for penal action under so and so. Similarly, it appeared that Sri so and so of so and so, from whose possession the goods seized was concerned, in possession, transportation, and or in any other manner in dealing with the seized so and so tablet, which he knew or had reasons to believe liable for confiscation under so and so. This Anup Kumar Singh appeared out there in what capacity?
He was the manager of
No, because he was acting as a transporter on behalf of the transporter.
yes, sir. He's the employee of the respondent.
So it was not his personal thing. Then what is wrong?
Notice was issued in the personal capacity notice. Kindly peruse the notice which has been issued by the respondent authority to the Anup Kumar Singh
Where?
at page 37. The next of 5.
Yes.
Anup Kumar Singh, Mr. Shubham Parmar, demand notice.
Now this Anup Kumar Singh, is he working with you? Is Anup Kumar Singh working with you? Then
There's no personal penalty was imposed on the Anup Kumar Singh, and thereafter the notice was issued, the demand notice was issued on the petitioner also. And even the person who purchased the medicine from the Dehradun to Aizawl, he was present before the respondent authority.
who?
The Aizawl, the Life Medicos.
No, you are not challenging those two orders.
I am challenging the notice which.
You are challenging that here you see the penalty was imposed upon Anup Kumar Singh, and how can this be put together? But unless you clarify in your order as to why the penalty has been imposed upon him, Anup Kumar Singh.
Page 27, paragraph 6.
Page
Page 27, paragraph 6.
yes.
Records separately also suggest that Sri Anup Kumar Singh of
Records available also that the Anu of so and so acted as a facilitator for transportation of the from the Guwahati to Ayer for ultimate smuggling. So it is on personally to him. If that is personally, how can you impose on the company? No, if he does not pay, you may at best ask the authorities out there that from his salary or the dues you may deduct. That is another thing. But you cannot impose upon the company because you have not, your order does not say unless you revise your order. Maybe. That is his address. Because your order categorically, you should, yeah, the order should have been more clear. Now, not being able to get the money from Anukumar Singh, who is not giving any value to your notices, he's doing it with him. You can very well ask them to deduct from his salary. That power, I think you have it under the Customs Act. You may revise your notice and tell him that you do one thing, get the money or attach that to portion of his salary. That you can do for recovery. I think you have a power. I think you can do so. Or whatever may be, that is your lookout. But when the order has imposed a personal liability upon Anukumar Singh, you can't implicate the petitioner. That's your case. Yes. And is Anukumar Singh a party? Party to the proceedings? Why? Because he did if your entire claim is on the basis of Anukumar Singh has to be liable, not you, why you are not making him a party?
There was no proceeding was there till 2018. For 2018, thereafter the first time the petitioner got the notice from the respondent authority.
Maybe whatever it may be, you are saying that Anukumar Singh personally was imposed an amount of rupees 2,50,000 by 2 orders.
Yes.
And as such, you cannot be made liable.
Yes.
The fact that Anukumar Singh is your employee still exists. He's still your employee. Why you are not making him a party?
I do not understand. Right now that even at present he is the employee or not.
May or may not, but then also don't you think that he has a right to say? Because the moment I say that yes, you cannot impose upon him, but you have to impose upon him, he's right to say that I acted in the capacity as a manager of so and so, and as such that is not there, is already finalized.
You see as per the original order and the notice earlier were issued to the Anukumar Singh, there is a personal penalty. Can you peruse that annexer 5, page 37, 38, and 39, 50? All the 4 notices were issued to the Anukumar Singh. Can you peruse those?
I've seen it.
And
But the fact is, Anukumar Singh was the person concerned who was your employee. He was your manager. And the goods were found in your custody. That is a fact. Then if you are not disputing, then what? No, Mr. Agarwal, I'm not on other things. If I pass an order that you cannot impose upon him, but you have to impose upon him,
they've already imposed one.
you have to recover from him. Then the problem will arise with respondent with that particular Anukumar Singh who would have no defense that I was acting at the behest of your firm. Can he say that after I passed that order? No. And wouldn't that be an adjudication ex parte against him? So how do you proceed with the instant proceedings without making Anukumar Singh a party? Let him come up I think he's the best person.
Looks like they have filed the affidavit also. Affidavit is filed with the petitioner. And in this, they have admitted that that liability is imposed on that Anu Kumar Singh, not on the company.
Is it?
Kindly, that is kindly peruse the affidavit in opposition. Filed by the respondent authority, and page 2, paragraph 4.
Yes.
That before giving Paragraph reply
Hmm.
to the awareness made in the petition, nor answering defendant begs to submit a petition that will be for the private limited was the employer of Anu Kumar Singh, against whom personal penalty of 1 lakh and 1,50,000 was imposed. By original order dated so and so. Again, in page number 4, by the above.
Mr. Agarwal, are you going to make Anu Kumar Singh a party or no? If you say no, I dismiss. If you say yes, I give you a chance. Either one, which do you? Fantastic. Mr. Taking into account the orders by which penalty was imposed upon Sri Anu Kumar Singh of rupees 1,50,000 and 1 lakh respectively, and who admittedly was an employee of the petitioner company. It's a company or firm? Petitioner company. It is the opinion of this court that without Sri Anu Kumar Singh made a party to the instant proceedings, any adjudication made in respect to the challenge to the notices impugned in the instant proceedings would not be in the interest of justice. Under such circumstances, the learned counsel appearing on behalf of the petitioner submits that he would take appropriate steps for filing an application seeking to implead Sri Anu Kumar Singh as a party to the instant petition and seeks for an accommodation of 4 weeks. List the matter again on November 15th, 2023. It is made clear that such application has to be filed by November 8th, 2023, failing which this court shall take up the instant petition for final disposal on its own merits.
13 and 14.
Mr. Agarwal, you had an interim order? There was no interim order. You don't require interim order.
In the meantime, notice of the notice stated the annexer 1 and annexer 3 may continue.
In the meantime, taking into account the issue involved, the impugned orders dated, impugned notices dated
6/3/2018 and 28/8/2018.
shall remain suspended till the next date. Yes, who is appearing for the petitioner? None appears. Both the writ petitions arises of the inaction on the part of the respondent Axis Bank as well as the concerned insurance company in not paying the ATM person. Oh, that one. Tell me. M. Sharma, Learned Counsel, appearing on behalf of Axis Bank, submits that although as per the terms and conditions had no liability, but he would like to take instruction as to when the insurance company as to which insurance in question at that relevant point was identified by the Axis Bank and what steps have been taken by Axis Bank. Yes, what steps have been taken? They have informed with a letter, if I remember correctly. What steps have you taken? There was no identification of any. So you may play the fraud upon the petitioners. Are you saying that? I don't think you should say that. The moment I say that, I'll record it in the order. And if I record it in the order, tomorrow it will flash it everywhere. That you have defrauded the people. By saying that, okay, you take my debit card, we'll have a 1 lakh insurance personal cover upon you. And thereupon, when the person asks, you are going to pay, say that, no, we have not identified anybody. Are you serious with your submission? Your instruction can't be limited when this court had made a specific query upon you, which Mr. Sharma on the last occasion had sought for. Where is he? Oh, fantastic. I'll record it. Should I record what you have made? Submission. Should I record what you have submitted? That you have not identified anybody? No, nothing doing. Your name? So and so, appearing on behalf of the Axis Bank, pursuant to the query made by this court by order dated 13/9/2023, had submitted that the Axis Bank, pursuant to its policy, pursuant to its ATM personal accident insurance claim benefits, had not identified any insurance company at the relevant time when the incident happened. This court at this stage finds it relevant to quote Clause 7 Clause 4 of the terms and conditions of the debit card under the heading insurance. Clause 4 to 5, page 45. From a perusal of the said clause, it reveals that the Axis Bank does not hold any warranty and or make representation about quality, delivery of the cover claims, processing or settlement of the claim by the New India Assurance Company Limited or any other general insurance company as may be identified by the Axis Bank from time to time in any manner whatsoever. This clause therefore makes it clear that either the New India Assurance Company Limited has to take care of the insurance policy, or such other general insurance company has to take care, has to indemnify, has to pay the insurance claim. The submission of the learned counsel that the Axis Bank had not identified any insurance company is a serious, is a statement made having a lot of ramifications, in as much as if that statement is true, it shall amount to defrauding the people who have been informed that with their debit cards there would be an insurance policy, that they would be covered by an insurance policy. Under such circumstances, this court therefore directs the branch manager, directs the branch manager, Axis Bank, having its office at GS Road, Chibar House, GS Road, to file an affidavit by October 6th, 2023. It is made clear that if no affidavit is filed, this court shall take up the instant petition for disposal on the basis of the statements so made by the learned counsel appearing on behalf of the petitioner of the Axis respondent number 1. List the matter again on 11th of October. Yes, Mr. What is this? They do non-payment. 21,000. He must have forgotten. To verify pay only. If not only. Huh?
17.
Yes.
It was concerning that the lift was constructed by the director's colleague in violation of the law, maybe the field. Initially, we had submitted a complaint case of the limitation of completed by a fund at page 14. 1 point.
What are you challenging?
I'm telling the order.
Recall and forbear from giving effect to the order dated passed by the District Development Commission. Writ of certiorari should not be issued and quashing these two. Again, respondent number 12 for admitted violation of the provision of Assam lift and escalators. Yes, what happened to you?
It was considered at page 15.
Huh?
It was considered the parties passed the market page might give the page 15.
Page 15.
With the direction to demolish the construction within 7 years.
Order. Silchar Municipal Board. OP. Who is OP? You. Respondent number 7. Complainant so and so is present personally along with advocate so and so. This is under what provision? Okay. OP abstained from submission as to the wine shop. Accordingly to her, she is neither the owner nor the possessor of the shop and she has nothing to submit. As to the main building, it is submitted by the OP that the building being so and so is lift is compulsory as such. She has constructed the lift, but remains silent as to the construction beyond permission and drawing. Admitting the construction of the lift, learned advocate for the after submitted that they have completed the construction prior to 6 months from the date of issue of the notice of action. Either submitted by the review of the OP is to remove the present lift position and its way inside the building. Secondly, the OP directed the owner's construction. Who are you?
I'm the person in the land abutting. I'm the person in the plot of land, parcel of land, abutting that land. My concern was the case, paragraph 14, saying that if a lift is constructed without permission and the unauthorized construction is there might be a collapse. Construction of lift is not like construction of a wall. it should take the load of the lift to carry. And this not only will affect the life of the dwellers there, but have an impact on my side. as
How
well.
are you affected?
You know, it's a common. But in land, this building room, once this falls down, my life is also in danger.
Is it? Show me a photograph.
But we have no next photograph.
Have you seen it with your eyes?
I have no problem on that.
Then how do we know?
This is
How
not,
is it going to affect? Let us see how is it going to affect.
can deny it's not there.
And what is this case?
Now,
This-
annexed D. If the other appeal. Which I think.
These are the appeal file. What happened to the appeal? There's a stay.
Now, so far as this is concerned, like the D order is concerned.
You are challenging which order?
Annexed D.
B, let us see B. What is it? Oh, B, I have read it.
D.
B,
70.
D.
Clearly, page 81, what's the final side?
As passed in order there on asking OP to remove lip and again.
Paragraph 7.
Yes,
Now, the response number 5 was final affidavit, saying that permission was granted, and granted, without annexing a document. to that.
the Silchar, that appellate authority also has come to a finding that there was a permission granted for ground and
That document is
second.
not forthcoming in any forum. That is it.
Do a RTI.
But if there is a permission.
You want-
I'm
Do you want to make this court a PIO?
on that.
Then
What we are on is that, as per the rules, they need a permission to first that. If you.
first of all, you have to satisfy me. How are you affected?
Why not? They need.
You are mainly saying that nearby, if the leaf may fall down.
No, they could not fall. The entire structure. would
How
fall.
are you affected?
Why not?
If he has a lift inside or outside, how are you affected?
Why not say if the lift is constructed? With the full-
Are you staying in that house?
in the abutting,
How, therefore, if it is abutted, with the lift fall in your building?
why not? If the building collapses, the weight of the lift, the structure is that is on the outer side of the wall. If that collapses, it comes to my land, it's the abutting land. Therefore, I say, without permission, what we do is that in them. Is that it? The initial authority found it correct and they will to stand by them if we have some permission to do so.
So what type of lift is this? Tell me,
What the absolute.
what type of lift? Is it the lift which we have with the Otis lift?
No, I don't know.
Or is it the lift with having these iron bars?
They have.
Is it the lift which, I remember staying out there, the Assam house in, what you call, Calcutta. They used to have a lift where it has to be run with a, because they have to be, this lift was run on something and handle, it had a handle out there.
Even today, in many apartments, if the lift, in fact, the electricity is disconnected and then it abruptly holds, then the manual method is still there. Can we get the next level? If the generator is there.
No, 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 there, here it used to be just manual. Means only it goes up, but then you have to start with this thing. There is a particular, the switch was not a particular switch. This has to be done like this. Anyways, what type of lift, how is it going to affect you?
No,
It is not clear.
this is that.
Hmm.
So, electric collapse into stone, and it will affect how part of the land and vehicle also.
Fantastic. If it is so, it is very rightly, means it has to be interfered. But the fact, how do I know?
If this query is following, the strong that the 2018 matter, what we have projected there.
With photographs, how is it affecting you? Without that,
May I say-
first, you have to show your bona fides.
The bona fide said that there's not even disputed with the other side. What I'm projecting only on the question,
They are disputing means they, how are you affected?
so we are not disputing the part, the fact that which are pleaded. That abutting land is mine. If it collapses, I am affected. Now kindly having it according to the rules, 1/6 Act and 10 rules, go ahead. Now the response number 5 says there is some permission granted but not against. I think no, we don't even case to that. If that is.
No, as regards the construction of the building, what do you have to say?
Construction of the building is fine.
You are
So
not
for
on the
additional
construction.
courts are concerned, that may be without permission, without recognition.
No, you are not with the construction, or with the, if the construction, if no permission, it may fall down.
That two parts. Lifting one and the additional construction can be other. They do not dispute to what I am saying. Only thing
No, does it affect your setback?
it would not affect my setback, it will affect my life.
No,
Everything would happen.
no, forget about the lift, the other way. Whether the additional construction will affect your
Setback
setback.
part I would not separate. Setback part I would not separate.
So then how are you affected with the additional construction?
Additional construction on the other
Are
part.
you thinking about the other people who may stay?
There is a one shot. only.
Huh?
I'm
You-
not against the one shot. I'm not against the one. This is a very well handled. So this part I will find additional material only a prayer will watch it. If the direction the respondent finds the permission on the what they find that will be the law.
Who is respondent number 5?
Respondent number 5 is the chief electrical inspector from advisor.
He has submitted the report
Affidavit. By an affidavit.
for what?
Stating that some permission was granted.
No, 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 we'll ask the, because the Silchar Municipal
Yes.
Board had decided everything and said that the permission has been granted. Mr. Dotto, are you supporting that order of the appellate authority?
You know, the,
You are not?
I'll take the lesson case 19. The place for order.
Page 19.
Fine.
Yeah.
So you can see regarding the additional constructions made there also. The appellants against that they had applied for permission for construction. The respondent number 1 chairman assembly made airport. Also the application filed. Other obstacles and the procedure taken in the level tax. Which the appellants have referred. And the government of which is referred to the reference to the respondent of the hearing of both the parties and parties best order in the interest of both the parties. So therefore, we will can be setback there. And we can decide in accordance.
No, 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 no. That is another thing. This is for additional construction. He has nothing to do.
Regarding additional.
He has nothing to do. Whatever happens to the wine shop, he doesn't frequent there.
When shop.
No, one shot I'm not touching on.
He doesn't frequent there. So the only thing is out here is as regards the lift. Now, are you saying that the lift, the order which has been passed in the lift has been done rightly?
That's
You are not
So he's
supporting it?
supporting me, please. And it's a me.
I don't, something I don't, I have to take stock of situation.
No, no, personally, Mr. Doctor, you don't appear personally, you appear as on instructions.
No one instruction, that's the reason, my lord, I would like to file an affidavit. That,
You have not filed your affidavit.
my lord, very sorry.
Okay.
He's supporting me and it's the B page.
How is Silchar Municipal Board doing?
Beg your pardon, sir.
How is Silchar Municipal Board financing?
Financial help.
No, financial. They impose costs, na? You have not filed your affidavit till now. The instant petition was filed by the petitioners, challenging the order dated 2/5/2018 passed by the District Development Commissioner. Whereby the order which was passed by the Chairman, Silchar Municipal Board, dated 5/2/2016, was interfered with. It is apparent from a perusal of Annexure B and Annexure D that the proceedings were initiated at the behest of the petitioner, which resulted in the Chairman, Silchar Municipal Board passing certain orders against the respondent number 5 or 6, 5 or 7, against the respondent number 7. This court have duly perused the materials on record and do not find appropriate pleadings as to how the petitioner has been affected with the installation of the lift or the construction so carried out by the respondent number 7. Mr. S. Bonik, the learned counsel appearing on behalf of the petitioner, submits that he will file an additional affidavit, bringing on record appropriate pleadings in that regard. It is also seen that the respondents, more particularly the Silchar Municipal Board, as well as the District Development Commissioner, Kachar, have chosen not to file their affidavits in spite of opportunity notice being issued as far back as on 25/5/2018. It is also seen that as far back as on 17/12/2018, the councils are representing all the respondents except the respondent number 8. Mr. Nath, you are not filing affidavit?
Why not?
You don't want to.
Why not?
You don't want to file affidavit. When? Cost? For you, big house, 25,000.
Otherwise, I can also make a submission for the documents.
Then I can take it up for final disposal now. We'll admit what the petitioner says and apply the doctrine of non-trespass.
No,
But you cost.
the first time that.
We pass the stay order. We pass the stay order, then only the things will improve. So, taking into account the above, this court fixes the matter again. When can you file your affidavit? Additional affidavit? Fixes the matter again on 9th of October 2023. Mr. S. Dotto, the learned senior counsel representing the Silchar Municipal Board shall produce the records in respect to the present proceedings and in respect to the proceedings which culminated in the passing of the order dated 5/2/2016. And who is the district appearing for the district here? District Development Commissioner? Miss S. Purva, appearing on behalf of the respondent number 1 and 2, shall also produce the records pertaining to the municipal appeal case number 3/2016 on the next date. Mr. M. Nath, the Learned Senior Counsel, appearing on behalf of the respondent number 7, seeks for an opportunity to file the affidavit on behalf of the respondent number 7. Taking into account, in the interest of justice, this court permits the respondent number 7 to file the affidavit by 4th of October 2023 without fail. It is made clear that if no affidavit is filed by the respondent number 7, this court shall dispose of the matter on the basis of the materials available on report, on the basis of the pleadings available. Yes, who is appearing? None appears on behalf of the petitioner and court. None appears on behalf of the petitioner as well as the respondents of court. You are appearing. Mr. Ardhar, that day one matter was there. That matter pertains to where I have asked this commissioner and of this WPT and all these people to appear in person. When was this date? That was item number 7 yesterday. There was none from the WPT or this department which were there, appearing in the court. You are for WPT?
The problem here is WPT from 22nd June 2022 is department has been bifurcated. Now one has gone to social development empowerment. I only look into this tribal development.
I don't know. The person, it is this authority who had done this, given the SC certificate.
Yes, it's not only issued by my lord DC.
DC is done, but there was some verification being conducted by this director of some,
Even if SC then my lord, you go to social development empowerment.
whoever it is, I've given them the directions to appear. Yes, today you are appearing. So you are appearing for whom?
My lord,
You are appearing for nobody. That department is no longer
that is
there.
what I have come from my lord. Or else there is a party with them.
Sure. Yes, Mr. Kotoke. Okay. Mr. S. Kotoke, the learned counsel appearing on behalf of the petitioner submits that he has instructions not to place them instant, not to press the instant petition. Accordingly, the instant petition stands closed on withdrawal. Interim order, if any, stands vacated.
21.
Item 21, I am supposed to file an affidavit because they gave us some more capable of the records have been given to the sub records have been given to.
So are you going to pay more money?
No, I have to.
Let us record it, what you are saying, that you want to pay more money.
According to that, according to that.
No, they have stated on the last occasion when the matter came up, you said on 11/9/2023 that look here, I have the instruction, I want to put it by way of an affidavit.
The instructions received is not clear. I have also called for the file.
Because they said that some more cases are there, because that is the from the, I have been looking from the fine, I have one for the fine. And I think sometime on that is just verified and accordingly.
Okay. Mr. matter again on 10th of October 2023, on which the affidavit which the learned counsel, which the learned senior government advocate, which the respondents were to file, which the respondents were to file in terms with the order dated 11/9/2023, be filed by 6th of October.
22 to 24. I don't know what to do, like, make up this method not important because it's civil case law case.
Huh?
The civil case law case, document appeal for the common or co-respondent law.
Whom?
That is not before your law. In this repetition, that part is not there.
Then,
So that part is said the part is law. But this matter pertains to actually not to the land, Akubari is there, not to- they remember not to.
Thakurbai.
That's what.
Then how is it relevant?
The civil case law-
Cursory should not be issued to set aside the impugn order dated so and so, whereby Deputy Commissioner is trying to interfere with the affairs of private land. Mandamus should not be issued directing the official to cancel impugn order dated so and so. Mandamus so and so.
There are two distinction laws.
But you see, the dispute in which I was appearing pertain to internal management of debt.
Yes, Lord,
It has nothing to do.
but that we have challenged that committee in the second. Exercise.
Is it?
No, Lord, it's like not that-
No, it's okay, no problem. Leave these matters before any other court. Before any other bench other than me. Yes, madam. Huh? Rebrief for what?
For Taj Mahal. And there were two agreements executed between me and the transport department.
Washing an order dated 12/7/2018, terminating the lease agreement dated 7/5/2003.
My lord, as per order dated 7/6/2019, my lord, person is complying, my lord.
Show me the lease agreement.
Priority is.
Show me the lease agreement.
Case of conflict, if this situation already deal in the prayer deal portion,
Priority is my lord.
earlier, the other place or
Kindly
elected
produce
place
your order dated 7/6/2019.
regarding compensation matter.
A writ in the manner should not be issued directly necessary to refund, reimburse the money paid as annual lease amount and expenditure borne by the petitioner in purchasing a plot of land. And yes, what is there?
My lord, as per my lord, paragraph 17 and 22, my lord, it stated that we have paid security amount to the tune of rupees 2,50,000 per year from the year 2010 to 14. My lord. This has not been controverted, my lord, and we will file an additional affidavit, my lord, where, my lord, we have annexed the balance statement, which shows that, my lord, as on date, my lord, we are entitled for payment of more than 4 crores of payment from the respondent.
Are you claiming that?
Yes, my lord.
Where?
There D, my lord.
A writ in the mandamus should not be issued directing the respondents to refund, reimburse the money paid as annual lease amount
And the expenditure borne.
and
by
the expenditure borne by the petitioner in purchasing a plot of land measuring so and so, and the two weighing machine installed at so and so.
Yes.
Interesting. Now, what is this? Were you in occupation of the land when you paid the annual lease?
From 2010 to 2014.
Were you in occupation?
Yes, ma'am. We are in occupation, my lord, but
Then why are you entitled for the refund of that amount?
that was the case money, my lord. That was the case money, and we are not allowed to operate the wage-based method because the BLC militants have ousted us from the plot, my lord. never allowed to operate the way we are. Instead of that, we are continuously paying the money for 2 days. And we have invested the amount, a large amount, for installation of machinery.
Do they admit that you were thrown out?
Paragraph 16, they have not.
If they are not admitting, then how this court can take into account this claim of compensation?
Paragraph in affidavit, the paragraph minor for affidavit, they have not said anything about that. They have no comments. Paragraph 16, we have made critical statement that we have been ousted from the land.
Who?
With the petitioner,
They've mentioned?
Councillor Kali had
they
a
have no comments.
affidavit been filed by the SP, Superintendent of Police. They have not,
We'll take it up at 2.
in fact, my lord has already first in the order, Mukul Bayan case, last week.
There is 2 agreements for executive between me and the Transport Department.
Yes, tell me.
And in respect of the payment of security deposit, it's on their part, it's 94. of the expedition.
94. Yes.
It is a part of the letter dated 29th month 2016. It was written by the commissioner to the additional chief secretary. Finally, on page 94, paragraph 3. Mention may be made that network because by enterprise has been paying government maintenance up to 15/6/2014. The admission on their part, my lord.
Till the period from 15/6/2010.
Yes, fine. By
Then-
2010, my lord.
Hmm.
In a second agreement, my lord, which was executed on 7/5/2003.
Hmm.
Because they will find it page 57.
It's okay. Then what has happened after? In the same letter dated, the commissioner directed the embassy to technically for reviewing the
Clause one,
function.
my lord. The second part is that install waivers of 60.001 capacity at its own cost. And the agreement will be for 10 years. Finally, come to the next page, my lord. That is clause 4. That this agreement can be considered for termination after providing reasonable opportunity for explanation. And thereafter on a notice of 1 month to remedy.
Are you challenging the termination?
No, man. Clause 5. Clause 5.
Hmm.
It was challenged by two other petitions, my lord. This was a stay. Therefore, my lord, I could not operate these vehicles from 2003 to 2010.
No, that is also there in page number 91, 93. Annexure 16.
Yes, my lord.
It is stated that on account of the litigation, it could not be operative till
Therefore,
15/6.
from 2003 to 2010, I could not operate the vehicle.
Okay.
After the vacation of the interim order, because the decision for default. Thereafter, I was allowed to operate the vehicle. And there. I
From
paid-
15/6/2010.
Yes,
Then,
I paid the security deposit, my lord. But my lord, during that period, my lord, I was ousted by the DLT militants. That fact is also admitted by them, my lord, and
where?
yes, I will come to that. Page 97.
Yes.
Present status. Then it goes.
Hmm.
It may be mentioned that a complaint was lodged by Mr. Vikalpa Enterprise by its partner, Mr. Koditeka, on 3/6/2011, stating that some anti-social activities led by one P. Jana Mohan Mutahari has captured the whole project of waiving forcibly from Mr. Vikalpa Enterprise. After receiving the complaint, this commissioner had issued a letter to the SP Kokrajat, dated 26/7/2015, request to provide adequate security personnel for resumption and recovery of the waiving of the original base immediately, as it is in collaboration with the Transport Department Government of Assam, with validity of extension up to 36/2020 for effective functioning of the state building. It is important, my lord, it may be mentioned that insert and this gets by this letter dated 14/3/2015 2016 clearly stated that a place of business for operating a railway originally established by Messrs. Vikalpa Enterprises under operation and management of Messrs. Jagannath Enterprise owned by Sri Janamohan Musare. DPO also stated that it is not known as to who had accorded requisite permission authority to Messrs. Jagannath Enterprise to operate the railway as such. Further, then DPO also.
But when, since when? Because that communication is not clear, because you are saying that on 6/20, in 2016 that was mentioned. And you are asking for the period from 2010 to 2014.
I will kindly come to page 19.
90?
Operating. This is the letter by the Commissioner of Transport by SP.
Yes.
With reference to the above, I have ordered to inform you that the Messrs. Vikalpa Enterprises entered into an agreement with Government of Assam Transport Department to operate railway as checkpost situated at Srirampur district, Uttarakhand. Assam for a period up to 36/2020, the above railway since its inception has been rendering low signified services to the base of its ability and contributes a considerable amount of revenue to the state.
Here also, Mr. Data, it is not clear from when.
During that period.
During that period, how can this court adjudicate that aspect? During which period? Isn't it a question of evidence? There is no quarrel that there was some disruption. June 2011 is your communication.
Oh my God.
Yes. Kindly see it. That is there in this particular communication which we have referred to in page 97. Kindly see page 97. Here you have received a complaint on 3/6/2011. Line number 2.
It may be mentioned that complaint was brought by me on 6/6/2011.
So the fact as to whether it had happened during what time is not clear. Because you are asking from 2010 to 2014. How can this court direct, if that is so, without knowing the actual fact, whether it is from 2010 to 14, unless there is a clear cut admission by them?
Commissioner, my God,
Where?
this my God, that letter at page 94.
That is what the page 94 also says, that there is a disruption. There is no quarrel that there is a disruption, but during what period? That is the question. Nowhere is mentioned from which period. You see, the disruption has been found out on the basis of a communication dated 2016. But for which period? That is not there anywhere. You see here at page 97, it has been mentioned, it may be mentioned that the then in charge MD Checkgate dated so and so clearly stated that the place of business for operating the weighbridge originally established by so and so is under operation and management. So this was done in 2016. But from which period this has happened? You were ousted. So this is the question of proof.
I not one claim, the lordship time permission I give the submission. Look, we are not claiming any loss or damages on account of loss. All that we are claiming is my lord, the amount of fee which we have given to the deposited to the government and the actual expenses which we have incurred for setting up the wheels. We are not asking for any compensation there. And those are all documented, those are all audited.
Understood. You have paid for 2010 to 2014.
That is one component, and my lord, there is some amount which have spent for my lord establishing the check. We are asking for that.
Now, is it permissible as per the agreement to get it back?
My lord, yes. Please come to the agreement,
Yes.
clause 4 and 11.
First, let us see from the agreement that you are to buy you have to buy the land. Because that is a part of your clause, the relief at clause D.
Yes.
Clause 2, I think, at page 49.
Yes. 57. Second.
The first also 49, clause 2. The required land for installation of the way bridge and
The second
construction.
agreement is at page 77.
Hmm?
Period was reduced by for 10 years.
Page 57.
Yes.
Yes. What does it say about the land?
Then the second part is shall install the weighbridge of 60-ton capacity at his own cost. That the weighbridge so installed shall be in continuity of all the relevant static rules, etc. The agreement will be valid for a period of 10 years, subject to effective implementation of and subject to satisfaction of first condition. This agreement can be considered for termination after providing reasonable opportunity of explanation and thereafter a notice of 1 month. Then for where violation or change is a fine. And the nature, number and nature of vehicles which are at present needed to be weighed at each second shall compulsorily be weighed by weighing established by the second party. However, the second party shall maintain a proper system, etc. Then second party will have to maintain all records, official or transport department, right to inspect. Second party will have to produce all records, etc. Second party shall have to pay security deposit of so it is form of a bank draft. 10. The second party shall have to pay lease amount of 2,50,000 that we have paid minus. That the recurring expenditure is likely to be incurred for maintenance of the project shall be borne by the second party. If situation so warrant, government of Assam shall provide interest security of the project at the government cost. Payment, etc. Second party shall provide all copies of orders, etc., which we have done, my lord. Second, will have to ensure the entire property gets all types of this. This is the agreement. So, my lord, there is no provision for buying back. But if we go by the spirit of section 70 of the Contract Act, my lord, I think they are bound to compensate us.
Understood. There's no quarrel that you are not to be compensated. You will be
No, it
compensated.
is absolutely correct.
But the fact that as to
It's been a case where I'm gaining any damage from a count of loss which has been.
now kindly come to page 49 of your petition, because this may give you something, if you see, or you may develop your case on that.
Right.
Clause 2.
That the required land for installation of the weighbridge and construction of office and for operations shall have to be provided by the transport department free of cost. However, it is not possible for the department concerned, second party will install the weighbridge on their own.
Now, can you develop your case on the basis that they could not provide for which you had to buy? Is it a part of your pleadings?
Yes,
That's
but
it.
in fact, the expenses part we have shown, my lord.
No, it
We
is,
filed an additional affidavit.
no, is it mentioned in your petition that they could not provide the land for which you have done this?
Like paragraph 6, we have stated matter.
Para 6
Yes,
of the petition.
6 and 10 matter. That thereafter, there was a change in the government. And during the subsistence of the agreement dated 26/4/01, it is the petition and the earlier government. It was described that the then government to enter into a substituted deed of agreement dated so replacing the earlier agreement with the petition. That in substitute deed of agreement, certain changes were made pertaining to the period of lease and lease amount to be paid to the government for the etc. Then paragraph 10, my lord. That being arrayed as a respondent contested the case by exchanging with yes, paragraph 10 matter. The interim order handicapped the petitioner as he had invested a huge amount in setting up of the weighbridge by buying a plot of land measuring a total area of 3 million 4 kata and importing the weigh machines of Every India Limited from Haryana amounting to around 17 lakhs to be installed at the Siddharpur thing. So the land they got could not give, so we, my lord,
But where is where is your pleading to the effect the land could not be given by them?
cannot get my lord.
Para 10 doesn't say that. Para 10 say that you have done it.
Huh.
You have purchased the
No,
land.
buying a plot of land.
Yes, you have bought a plot. There is no quarrel that you have purchased. But where did you purchase the land because they have failed to hand over the land? Where is the pleading of?
So, my lord, the fact that we bought the land necessarily implies that they will, because otherwise we have bought. By buying a plot of land.
Understood. But the thing is here, the thing is like this.
No, my lord,
In order to get a writ for payment of that money, it has to be absolutely clear and distinct that you can't draw this or that.
No, my lord, there is admission to the effect, my lord, there is no denial to the, my lord, this amendment of. And you see the affidavit of the government, paragraph 10, my.
No, can they deny that you have not purchased the land? They have. But if you had made a statement that they could not provide you, for which you have compared to purchase the land, is a different aspect of the matter. And if that statement is not.
But my lord, perhaps, my lord, the pleadings are not, I mean, as is required to be. I think, my lord, that is what they wanted to provide it. They wanted to say that only, that since government could not provide the land, therefore, otherwise, my lord, if government will provide the land, question of the conditional buying doesn't have right. So, my lord, therefore, my only submission is, my lord, applying the principle of section 70 of the contract act. At least, my lord, the reasonable cost should be reimbursed by the government. I'm not asking for my loss of profit.
See, the question of reasonable cost means who is going to decide them?
Naturally, my lord, we have brought on record the materials. If the lordship will kindly allow me to place paragraph 4 of my additional affidavit. It was filed on 24/9/2018.
Because this comes within the ambit of a breach of a contract. And for that, you are asking for compensation.
No, we are not seeking compensation. We are only seeking that amount which you have spent, not compensation.
No, you have spent out there very well, but you are, as per 73, if we go by that, if we say that, it has to be on actual, because they actual. So this is 73. Because that our law in India does not contemplate the any other damages except special damages, which is specific only to the amount of expenditure or loss incurred, and that to subject to proof.
Subject to. So, my lord, whether this can be treated to be subject to, my lord, paragraph 4 of the additional.
But can this court do that? 226. Difficult.
My lord,
Because what you are doing for only getting this 10 lakhs, I'm just saying, for getting this 10 lakhs, you're waiving many other things.
correct. So what I expect you to play, my lord. My lord, the lordship direct the government to take note of everything and pass a speaking order on our case. If we are able, then we will see, my lord, we go to Supreme Court. The government take a pass an order. When regard to it.
Now, have you submitted a representation asking for that amount?
But the interim order is the rejection of the law.
Let's see that.
Yes.
We'll wait.
Our application is from page 98 and the order is at page 103, my lord.
For extension of agreement, my lord.
Whereas an agreement was signed between the transport department, government and the
It is not for the purpose of damages. It's for that you have asked for extension, which has, they say that it was never there beyond 2013.
But order also will file a representation final and government decide it.
Anyways, you have to do a section 18 notice.
So for filing a suit. So first would like to go to them. or my lord, that.
You have to do a section 80 within 60 days. You do it. Because what you are asking, just for this 10 lakhs, I don't think you should do. Because I've done many matters of this. At the end of the day, you lose more. Because this court will direct them and then thereafter they will close your eyes. That is the only way out. And there is no arbitration clause.
There is no arbitration.
Because the other things you are not asking, huh?
No.
Because quashing of the terminating.
Prayer notices issued on prayer deed.
Anyways, but the prayer deed notice was issued, but it would not preclude you for asking for damages for this. Because there are various averments made wherein it has been mentioned that or documents that it has been extended to 2020.
I think my lord, we will have to invoke the provisions of section 14 of the Limitation Act of Limitation.
No, I'll make it clear that this matter was pending out here, so you get the benefit of that. I think that is a better option. The instant writ petition has been filed by the petitioners, challenging the termination of the lease agreement by the order dated 12/7/2018. Yes. As well as also seeking mandamus. Directing the respondents to refund or reimburse the money paid as annual lease amount and the expenditure borne by the petitioner in purchasing a plot of land measuring 3 bighas 4 kathas of land and the 2 weighing machines installed at Srirampur MB Gate. Check it. The case of the petitioners here is from the perusal of the materials on record, it is seen that initially an agreement was entered into between the government of Assam in the transport department and the petitioner on 26/4/2001 for installation of a weighbridge at Simultapu, Srirampur. Subsequently, on 7/5/2003, another deed of agreement was made with the transport department, government of Assam, in respect of the said government of Assam with the petitioner. And the validity of the said agreement was for a period of 10 years, subject to the satisfaction of the government of Assam Transport Department. This agreement, which was entered into between the petitioner and the government of Assam, was put to challenge before this court in WPC number 4052/2013 or 2003. And in view of a stay order, in view of certain interim orders, the said weighbridge for which the agreement was entered into could not be operationalized till the period of 15/6/2010, when the interim order passed by the court in WPC number 4052/2003 was vacated. It is the further case of the petitioner that although the petitioners were permitted to undertake compulsory weighment of the goods laden trucks at Srirampur MB Gate on the basis of the agreement dated 7/5/2003. But on account of certain disruptions being made by the miscreants, the petitioners were not in a position to operationalize the said weighbridge, for which on 3/6/2011, a complaint was lodged before the Commissioner of Transport as well as to the Superintendent of Police, Kokrajhar, to provide adequate security persons for resumption and recovery It has been also stated that there was a extension. There was an extension granted. It was also stated that in the meantime, the responding authorities were considering to grant extension to the petitioner up till 30/6/2020. However, by the impugned order dated 12/8/2000, 12/8/2018, 12/7/2018, it was held that as the agreement dated 7/5/2003 had no provision for extension beyond 2013, the question could not, the granting of extension to the petitioner could not be, did not arise. It was mentioned that the agreement automatically stood cancelled on the day when the agreement ended. It is under such circumstances that the instant writ petition has been filed seeking the relief as aforementioned. It reveals from the records that on 27/8/2018, this court had only issued notice on the question of compensation, on the question of payment of compensation to the petitioners, on the question of only on the issue pertaining to recovery of dues to the petitioner, which was sought for in prayer D. The record further reveals that the respondents have also filed the affidavit wherein the claims of the petitioners have been denied. I've heard the learned counsel for the petitioner, Mr. K.N. Chaudhary, the senior counsel, who submits that the petitioner have sought for refundable reimbursement of the money paid as annual leaves That is an amount of rupees 2,50,000 per year, which the petitioners have duly deposited with the respondent transport department. And also the expenditure which was incurred by the petitioner for purchasing of the land, as well as the 2 weighing machines installed at Srirampur MB check gate. I've also heard Miss MD Bora, the learned counsel, appearing on behalf of the transport department. Who submits that from the materials on record, it is not clear as to whether clear that the petitioner was not able to function during the period from 2010 to 2014. And as such, the question of reimbursing or refunding the said amount to the petitioner does not arise. Further to that, it was also mentioned that a perusal of the agreement would not show that the petitioner had purchased the land after duly intimating to the government that they are going to purchase the land. And as such, the question of reimbursing the said amount to the petitioner did not arise. This court, after giving due consideration to the matter, finds that there are disputed questions of facts which cannot be adjudicated upon as to whether, in as much as to whether the petitioner could not operate the weighbridge during the period from 2010 to 14, whether the petitioner could or could not operate the weighbridge during the period from 2010 to 14. Or as to whether the petitioners have duly informed the respondent authorities before purchasing the land in question, and that they would claim compensation, that they would claim the refund of the said amount. As well as to whether the petitioners have also informed the respondent authorities prior to purchasing the 2 weighing machines. These aspects of the matter could only be adjudicated by a competent civil court. This court also finds it relevant to take note of another submission of Mr. K. N. Chaudhary, the senior counsel, wherein he submits that it is apparent from the facts admitted that though the agreement was entered into with effect from 7/5/2003, and the period of 10 years, for a period of 10 years, but on account of various interim orders passed by this court, the petitioner could not avail the benefits on the basis of the agreement.
Against the petitioner, only the clause 5 has to state they're running their business and lawsuit can handle the issue.
Wait, I'm not saying that is his submission. You have to give all these things. Now, how will you go to the court then? Otherwise, I could have said that, okay, Mr. Keynes only has wanted to withdraw and file a civil court. Then how do I give him the benefit under section 14? Yeah. Legally.
It is also, it is apparent from the facts admitted that the agreement was entered into with effect 7/5/2003 and that period of 10 years on account of various including other parts by this court. The petitioner should not avail the benefits and the purposes.
Until 15/6, na? 15/6/2010. The petitioner could not operationalize the way breach. And as such, the non-granting of the extension to the petitioner have caused serious prejudice to the petitioner. On the other hand, Ms. M. Deborah, the learned counsel appearing on behalf of the Transport Department submits that by the interim order dated 15/6/2010 or 10/6/2003, 10/6/2003, the only clause 5 of the agreement dated 7/5/2003 was challenged. And there was no bar on the part of for the petitioner to run the way breach. This court is of the opinion that these are all conflicting claims which also cannot be adjudicated upon. Not only on the question of disputed questions of facts, but also on the question of ascertaining the quantum of compensation. Under such circumstances, this court is of the opinion that a writ cannot be issued in the instant proceedings as sought for. For which the instant writ petition stands dismissed. Next. Be it as it may, this court observes and clarifies that the petitioner herein shall be entitled to, shall be at liberty to file appropriate proceedings before the competent civil courts, seeking the compensation and damages from the respondent Transport Department. The dismissal of the instant writ petition for the reasons aforesaid shall not prejudice the petitioner in such proceedings so initiated. This court also finds it relevant to observe that the petitioners have been pursuing their claims diligently and bona fidely before this court. And under such circumstances, the petitioners shall be entitled to the benefit of section 14 of the Limitation Act 1963. For during the period the writ petition is pending, that is, with effect from, that is, the period from 16/8/2018 till date shall be both inclusive, shall be excluded while computing the period of limitation.
In their petition, they have stated that the person, Jana Mohan Basumati, they have engaged the person to run this thing.
No, let it be, let them do. You take the petition, take a certified copy, show it.
Answer if you have that.
Six.
Service is complete. What is this matter?
Respondent authority, respondents are my legal. They issued a CBC against me by taking Italia that we wanted to evict them from their protection. And this landed municipal granted India. The effect that the land in question could not be sold out. And another order was also passed to the effect that for the mutation is concerned, that could not be altered. Despite that, the mutation has been altered. And that is when we have.
Go there before the Munsif. Why you are before this court? Why are you before this court? Any order being passed or anything done shall have no consequences. It's a nullity. Why have you approached this court? When there is already a matter pending.
Yes.
Yeah. And when there is already any order being passed, first of all, mutation does not confer any title. You want to pay during this period. If I was there, I would have been happy. It is otherwise a nullity.
Yes.
Now he is paying. Let him pay. Very good. Mutation does not confer any title. Huh? Was the impugn order dated passed in misbehavior dated in order dated passed in mutation? Then what remains?
The order is, the first order is located at page 27. The element portion is at page 28.
Then
Then below 28. Last line below. However, the opposite party is strictly restrained to direct and not to sell the 20. Directed not to sell the fruit land to third party until discover of this. That is, this order is against me. Now you are looking come to page 29. The element portion is at page 30. Okay. Hence, the prayer is allowed. The Borkhetri Revenue Circle Officer specifically is directed not to cancel the mutation of the petitioner until disposal of the. Now we are to come to page 25, 45.
page
Page 44.
of the petitioner. Who is the petitioner? Who is the petitioner? You are the plaintiff.
I am the defendant.
Then how did you become, were you the petitioner? Who was the petitioner in this application?
I was the defendant.
The defendant became the petitioner.
In one case, the plaintiff become the petitioner and their application was entertained. The effect that the defendant shall not sell his land. And we
And
also-
where is that mutation order?
Mutation order is at page 44.
Page 44.
And
This is not a
also
mutation order.
added to the-
This is not a mutation. Interim order passed by
No,
so and so,
that's
so and so.
page
so.
33 allotted.
Yes.
Page 33,
Page
33.
Annexer 8.
33.
Parking officer Borghetti,
Hmm.
who was directed not to change by invitation.
Where?
That is in part, page 30. Page 30.
Hmm?
Actually, yes.
No, that I read it. Where is that impugn order?
Now we are from page 36 hospital.
Page?
Please visit that.
This is, you file an appeal against that.
I felt it.
Okay.
No, that appeal has been dismissed.
It's okay, but that is okay. But now we are concerned with where is the order passed by the circle officer? You are challenging which order?
Already.
You have not enclosed. Withdraw, move before the authority is concerned. This is not done. First of all, how can this court decide and as to whether that order you have placed it before the authority?
Yes, yes,
Where is it?
yes. That is my case, no?
Where is it?
Legal point, page
Page?
32.
Yes. 29/6/2017. You have placed it.
Order passed on 31.
31/2018 is the order and you have placed it on 29/6/2017. How is it possible? What to do? Dismiss or withdraw? No place for dismissal. You have not placed that you have placed. First of all, the circle officer or whoever it is not a party to that suit. He's not a party to the suit. Obviously, he cannot be a party to the suit. And if he is not a party to the suit, the injunction may be passed against their officials, directing whatever may be. But you have to inform him. Where is your information? So, what to do? Withdraw, dismiss. Dismiss will be more prejudicial. Withdraw will be better to avail remedies before the authorities. You can very well take now that order and show it. The learned counsel, Mr. A. Dasgupta, the learned senior counsel appearing on behalf of the petitioner, submits that instead of agitating the dispute herein, he would like to file an application before the, who has done that? Before the circle officer. Circle officer Borghetti, na? Circle officer Borghetti. Drawing Borghetti, pointing out the order passed by the learned Munsif in Mizze case number 73/2017 arising out of title suit number 31/2017, whereby there is a direction passed by the learned Munsif that the Borghetti Revenue Circle Officer shall not cancel the mutation of the petitioners until disposal of the suit. Taking into account above, the instant writ petition stands closed on withdrawal, and the withdrawal of the instant writ petition shall not prejudice the writ petitioner to approach the authorities concerned. Interim orders, if any, stands vacated. What happened? None appears on behalf of the petitioner on call. it further seems from the records that the petitioner had not appeared in the incident matter on the earlier two occasions, taking into account above the petition stands dismissed for non-prosecution. Yes, Mr. Roy.
Well, the PPF or employee provident fund organization was, the government of Assam transferred 10 acres of land to them, in the year 1985 for construction of their office and water staff project. Then thereafter, some persons in the year 2006, page 29, Lordship kindly see, and opposed this for page 29. Praying that this land should be allotted to them, because they said they have been standing there. Now, this court has rejected refused the requisition and granting liberty to the government to, if they desire to allot them the petitioner some nearby areas.
No, Mr. Roy, has the land been allotted settled to you?
Yes, we have paid we have paid about 61,000, 100% market value of the land. That is,
Understood. Where is the order periodic lease?
page 15.
Page?
Page 15.
Page 51
15.
or 15.
15.
Yes.
This has been allotted to us and we.
No, the land has not been allotted. It has been only, this is an approval.
Thereafter, we made payment, kindly see.
Payment has been made, but where is your settlement?
It is a transfer of land. It is a
How?
transfer. So we made payment 100%, 25 years, accumulated land revenue and all.
This is an allotment. This is a settlement. Unless you are given the settlement, what right do you have? You may be in possession at best.
The government, the DC, thereafter pursuant to the order, DC has passed various orders. And they directing the DC to allot this land to us.
The simple thing that DC should have done is issuance of the periodic patta. Why the DC is not?
There is already an order of the government directing to correct land revenues and take necessary steps. Thereafter.
Maybe, but then also they have not done it.
They have not done this. That's why we have approached the DC repeatedly. Finally, the order is passed by like this. Also, we kindly see. Page 50 is the last order. After that, the government they have not taken any steps because since the land was occupied by some other person, the instant settlement officer has given us instruction. I noticed kindly see. Page 46.
Yes.
He said, page 46 down below. However, while the revenue authority is ready to show boundaries and so, your department is requested to provide logistics, labor and so. Your department is to assess the above requirements and so. The department should come ready with equipment. The department should add to the police civil administration. Thereafter, I will say.
No, all four of them are useless unless number one is there.
Number one is below there, that is not there. That is why we are approaching time and again to the DC. They have not taken any steps, bro. We have made payment. They have not taken any steps. That's all.
So if you are not doing it, then you have no right over the land. How can you ask for eviction of somebody from that
No, we
land?
are not asking for eviction.
Isn't that your prayer made in your petition? You are asking for that.
That's it.
And to hand over the vacant possession of the land measuring 10 bighas covered by dark number so and so, and hereby evicting those illegal and occupiers and all.
Because
made.
DC has directed the.
What is maybe and why are you not making them a party when you are asking a writ against them?
No, we do not know how many people, who are the persons, we do not know.
If you don't know that
Because minority fancies, their affidavit, it's a settlement officer's affidavit. He only said, since some persons are there, we cannot, we said, you give us some other land, and we said, give us some other, we make payment.
where is your prayer there?
Minority fantasy.
No. With petition, where is your prayer?
There we did not say, we filed a rejoinder, we said, give us some.
No rejoinder, Mr. Roy.
After seeing the.
Mr. Roy, no rejoinder business. The first and foremost, either you amend your prayer. If you want or do whatever, maybe this court is not going to pass this order unless you make those people a party. Because as of now, you have no right.
No,
A right shall accrue upon you only upon a periodic leave being issued. And I passed 2-3 judgments. I'm very particular on this stuff.
that is that. But my lord, our right is because
No, you have no right.
we make payment.
So,
The government is bound to.
okay, refund him the 61,000. Yes, government.
We need payment. No.
Yes, government. Who is appearing for the government? Okay. None appears on behalf, when the matter has been taken up, none has appeared on behalf of the government. The Deputy Commissioner Kamrup Metro shall be personally present on the next date fixed. Then, when we're calling this thing, why you are not, none of you are responding? Yes, government. Who is appearing for the Deputy Commissioner? When are you returning back the 61,000 back to him? How much? 6,18,000. Return along with interest at 12%, 18%. Next 3 weeks. Return the money. 6,18,000 or allot the land to issue the settlement because there is already an allotment letter.
Or shall I have the latest information whether they have already done it?
Whether they have. Then you are not aware.
June 22nd. This is of June 22nd. 2022.
So now
Second.
the interest have only gone up by another 12% from 1986. Pay them 3 weeks.
Okay.
We take it as your undertaking. You get the money back. The 12% interest. The instant writ petition has been filed by the petitioner, seeking a direction upon the respondents to act in terms with the directions passed by this court in WPC number 636/1999 and to hand over the vacant possession of the land measuring 10 bighas covered by DAG number 1, 2, 52, 53, 54 old, 2, 5 new of village number 2 Bokhisto under Beltola Moza at Guwahati to the petitioner by evicting the illegal occupiers and to make necessary correction in the relevant revenue records by entering the name of the petitioner number 2 in place of Sarkari land as per the order of the Governor of Assam communicated by letter dated 19/9/1985. From a perusal of the materials on record, it transpired that on 19/9/1985, the Deputy Secretary to the Government of Assam, Revenue Settlement Department, had directed the Deputy Commissioner for transfer of Sarkari land measuring 10 bighas covered by DAG number 1 and DAG number 53 of village Bokhisto under Beltola Moza to the Regional Provident Fund Commissioner any reason for construction of office building and staff quarter on realization of a premium at 100% of the market value fixed at rupees 61,800 per bigha, together with capitalized land revenue for 25 years at rupees 375 and local tax of rupees 93.75. It was further directed that the land may be handed over to the authority of the Regional Provident Fund Commissioner, any reason, and necessary record may be corrected after realization of the due premium. It further reveals that pursuant to the said order, the petitioner deposited the said amount of rupees 6,18,000 as well as rupees 468.75. In the head of account. Subsequent thereto, by the communication dated 25/6/1986, the Deputy Commissioner the Assistant Settlement Officer, who has handed over the possession of the land was handed over for the purpose of construction of the office of the Regional Provident Fund Commissioner on 28/6/1986. It is also seen that on the basis of the order dated 19/9/85, one bigha of land under dark number 1 and 9 bighas of land under dark number 53 was remarked, was inserted in the remarks column of the Chitta as reserved for the office of the Regional Provident Fund Commissioner as per allotment. It is further seen from the records that certain persons filed a writ petition seeking a direction upon the respondent state authority to give settlement of government land under their occupation. The claim of the said petitioners was in respect to 12 bighas of land covered by dark number 53 of village number 2 Bokhisto under both Beltola Moza for last 20 years. In the same proceedings, the petitioners herein were the respondent number 6 and 7. And it was informed to this court that the petitioners have duly paid the amount, the premium. The said petition, that is WPC number 636 of 1999, was disposed of by an order dated 7/2/2006. With a direction upon the respondents, with an observation that the respondents shall be entitled to evict the petitioners of the said proceedings, following the due procedure established by law, if not already followed. It was further observed that the respondent authorities of the state of Assam may also consider adjustment of the petitioners in any manner in any nearby land if the same is possible on their part. It reveals from the records that the petitioners thereupon have been approaching the respondent authorities seeking a direction upon the authorities, asking them to evict the illegal encroachment over the land which have been allotted to the petitioner, and in respect of which the petitioners have duly paid the premium. However, the respondent authorities have turned a cold shoulder to the various requests made by the petitioners. And as such, the petitioner has been compelled to approach this court by filing the instant writ petition. It reveals from the record that pursuant to the issuance of notice, the Circle Officer, Dispute Revenue Circle, had filed an affidavit in the same affidavit. It was mentioned that as per the available office records of Revenue Village Bokhisto under Beltola Moja, the DAG number 1, 2, 52, 53, and 54 are old DAGs. It is seen from the records that the aforesaid village and the Moja, the new DAGs are 4, 5, and 6, have originated from the aforesaid old DAG number 1, 2, 52, 53, and 54. It was further mentioned that during field verification of the LR staff, it is seen that presently approximately 71 numbers of families are residing on the land covered by DAG number 4, 5, and 6 and constructed residential houses thereon. It was further mentioned that in this area, water treatment and supply plant, public well, electricity pole, Lord Shiva temple, meeting hall, church, etc. are seen. During field verification, possession of the petitioner have not been seen on the land covered by DAG numbers 4, 5, and 6 new of the aforesaid village and Moja. The petitioners thereupon, it is also seen from the records that the petitioners have filed an affidavit in reply to the affidavit in opposition filed by the respondent number 3. In the same affidavit in reply, it was mentioned that the respondent number 3 had only given the present status of the land, stating that the land measuring 10 bighas is found to be occupied by 71 numbers of families by constructing residential houses thereon. But the same position of the land being occupied and encroached by others have already been found by this court way back in the year 2006. It was further mentioned that the respondent authorities had, in utter disregard to the order passed by this court on 7/2/2006 in WPC number 636/1999, did not hand over the possession of the land to the petitioner. In spite of the petitioner representing before the respondent authorities time and again. It was further mentioned that the circle officer, Dispur Revenue Circle, had earlier written a letter to the petitioner on 3/8/2017 and had requested the petitioner to provide the logistics, manpower for the purpose of carrying out the eviction. I've heard the learned counsels for the parties and perused the materials on record. This court is shocked and surprised at the attitude of the respondent, Revenue Department, and at the attitude and the manner of functioning of the Revenue Department of the Government of Assam, the Deputy Commissioners or the Deputy Commissioner Kamrup Metro, as well as the Circle Officer, Dispur Revenue Circle. This court at this stage finds it relevant to observe that the petitioner herein, number one, herein, is the Central Board of Trustees of Employees Provident Fund Organization, which is an authority constituted under Section 5A of the Employees Provident Fund and Miscellaneous Provisions Act 1952. The same office, the same land was allotted as far back as in the year 1985 for the purpose of constructing their office, Mr. Roy?
Yes, office and staff building.
Office and staff building. But for reasons best known, the Revenue Department of the Government of Assam, the Deputy Commissioner, Kamrup Metro, as well as the Circle Officer, Dispur Revenue Circle, have even not cared to take any action pursuant to the allotment order, the payment of revenue, payment of the premium, as well as even after the directions passed by this court in the year as far back as in the year 2006. This court further finds it relevant to take note of that on 27/2/2019, the notice of motion was issued. And in reply to this end, the responding authorities have not taken any decision, have not filed, even care to file a detailed affidavit in the matter, except the circle officer filing an affidavit to the effect that the land in question, which was allotted to the petitioner, is in occupation of other persons. This very aspect of the matter was very much there in the year 2006, as is apparent from the order passed on 6/3/2006 by this court. Seven to 2006 passed by this court in WPC number 636/99. Wherein this court had also made it clear that the said petitioners in the writ petition be evicted by the respondents by following the due process, by following the procedure as per law, and to hand over the possession of the land and observe that the petitioners in the said writ proceedings can be evicted by the respondents by following the due procedure of law, by if not already followed. Under such circumstances, taking into account the manner in which the respondents herein have been dealing with the matter, and it seems the respondents are not interested in honoring the allotment on 19/9 to 1985. Thereby issuing the settlement in favor of the petitioner in respect to the land, this court directs the commissioner and secretary to the government of Assam, Revenue and Disaster Management Department to forthwith to take an appropriate decision as to whether the land which was allotted to the petitioner by the communication dated 19/9/1985 would be settled with the petitioner And if not, whether the petitioner can be allotted some other plot of land. It is, however, made clear that if it is the decision of the Revenue and Disaster Management Department of the Government of Assam that the land allotted to the petitioner cannot be settled, or any other land cannot be settled, the Revenue and Disaster Management Department of the Government of Assam shall refund the amount deposited by the petitioner within 3 months from the date a certified copy of the instant order is served upon the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department. The said amount which the petitioner had deposited shall be refunded along with interest at the rate of 18% per annum from the date of the deposit till the date of payment. It is further directed that in case the said amount is not paid as stipulated herein above, upon rejection of the allotment and upon rejecting that the petitioner be it is further directed that in case the petitioner, in case the commissioner, if the Revenue Department, Revenue and Disaster Department of the Government of Assam is and upon coming to the conclusion that the land cannot be allotted to the petitioner, settled with the petitioner, and the payment is not made within the period as stipulated herein above, the petitioner shall not only be entitled to resort to such remedies available under law for violation of the orders passed by this court, but shall also be entitled to a further interest of 6% above the 18% from the date of such default.
Regarding anomaly in the disbursement of tax relief. The two reports were received, one from the Commissioner Lower Assam Division and the other from Special CM Division. So these two reports are being placed before Revenue and Disaster Management Department. The committee has been constituted. The committee is examining those reports. There is a large scale anomaly in this that is started. The committee report is available.
When? How long is it going to take? Mr. A. Bhattacharjee, the learned counsel, appearing on behalf of the Revenue and Disaster Management Department of the Government of Assam, submits that two reports have been submitted by the reports have been submitted by the CM Vigilance and
Commissioner Lower Assam Division.
the Commissioner Lower Assam Division as regards certain anomalies in the disbursal of the amounts of the flood relief. And before the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department. And a committee thereupon has been constituted by the Revenue Department of the Government of Assam, looking into the claims of the parties. He submits that the said report can be expected within a period of three weeks. So taking into account the above, list the matter on 24th of November 2023. The respondent, the Commissioner and Secretary to Government of Assam Revenue and Disaster Management Department, shall ensure that the reports are placed before this court on the next day fixed.
34.
Yes, what is your instruction, Mr. Chair? Yes, how much time? No, it can't go on.
Once again would be checklist. If it comes, then revenue department will consider.
We'll having it on 24th of November. Get whatever is done. Pursuant to the order dated 30/8/2023 passed by this court. Mr. A. Bhattacharjee, appearing on behalf of the Revenue and Disaster Management Department of the Government of Assam, have placed an instruction issued by the Additional District Commissioner Dhubri that the proposal which was submitted on 28/2/2017 by the Deputy Commissioner Dhubri have been returned for re-examining the proposal and for onward submission to the government. This statement is being made by Mr. A. Bhattacharjee, the learned counsel, standing counsel, on the basis of an instruction issued by the Additional Deputy Commissioner, dated 26/9/2023, which is kept on record and marked with the letter X. This court had duly inquired as to how long it would take, taking into account that for the last 7 years, the allotment of the 17.5 lectures of land has been, the question of allotment of the 17.5 lectures of the land has been pending before the authority is concerned. Mr. A. Bhattacharjee submits that the Office of the Deputy Commissioner Dhubri has to re-examine the proposal and has to submit. And immediately thereupon, the Revenue and Disaster Management shall do the needful. List this matter again on 24th of November 2023. On which date Mr. A. Bhattacharjee, the learned standing council shall apprise this court as regards the further development in the matter.
After the order to supply of pipe, to the public and engineering department. Suppliers will make expenses. Can be paying for five years. Here, if I will, the immediately deny my exercise waivers and say that I am to go to the fire, I'm to go to the specification of the micro and small in the chemical specification. So what happened, they only ignored that I am registered, I elected and I have a year partner in state. And Dr. Patel in fact gone to the MSME and the MSME award was passed. This is why that passed.
Award has been passed,
Yes, sir, this by the MSME.
my dear,
MSME.
has passed.
Dr. By, coming page 59, selected 7 to my register. Coming to 59. The relevant portion is page 60. Micro and small enterprises council by application on the district against the public health engineering department for non-supply of payment of this. In the 9th meeting held on 22nd 2021. Oh my God, sir. On the 9th meeting ended 21, the seller was absent. The representative of the state informed that only 8,67,000 is to be paid to Assam Polymers and the demand for the same has already been moved.
How much is the interest?
Interest will be estimated in the act of provide for calculation of the interest to vary with the reserve bank. Firstly, I don't have a copy of the additional affidavit. Firstly, what had happened, if I goes to page 14.
We'll go before
Page
the,
14, madam, see the MSME registration validity.
who is Mr. R. Talukdar appearing on behalf, who have received on behalf of Mr. P. N. Gupta?
How my
Yeah.
So
you cannot say that you are-
I'm not reversing on that.
So don't mix us things.
Now it is important. So why don't we go to page 14?
Hmm.
Page 14, but you see this 2 years, the validity is of 2 years.
Hmm.
It was of 2012, it expired in 2014.
Hmm.
What are the work orders are of 2015? So the element of MSME was disputed by us. But since now I have gone to this MSME council, and since it passed an award, in my limited understanding, the award has to be executed as per section 36 of the Arbitration and Conciliation Act. MSME award has to be executed. If they want execution, they want payment of bill, if they have the award against us, Arbitration and Conciliation Act of section 36, very defined and limited knowledge of section 36 has come. So this is probably they have to resort to that. Okay, what is the way of denying me all the time? You make me do work as a right. Of course, our government DHA department is known for not making payments.
Okay, she will go into the question of arbitration as regards the interest, but where, what about the 28 lakhs? When are you paying?
Without the element of
Where,
MSME.
no, there, before the MSME, you have duly admitted at page 60. You have duly admitted that this amount of 28 lakhs and odd, you are liable, and on account of the non-availability on account of the ceiling having expired, you could not pay. First pay her the 28 lakhs, then she will very well go there and fight out for the interest.
If the component of MSME is not there, we have admitted that that is
When?
entitled.
When,
Well, it requires certain, perhaps, my lord, certain time maybe.
yes, we pay. You pay this amount within 4 weeks.
As per the award.
No, award you okay, but interest, he has said about that, interest you fight it out. Go out there and get everything is done out there, but the question of interest, but 28 lakhs, you get it within 4 weeks.
So, it is very important.
I'll say 4 weeks, rather than say 4 weeks. Quantum will there, madam.
No. I'm not going as per you. I'm fixing a date. I'm fixing a date. You have to make the payment. Else, if you don't make a payment, the interest will accrue thereupon apart from the MSME Act. And that interest shall be recovered from the.
It has been paid.
Huh?
28 lakhs, there's a, will be paid.
No, it is not paid.
It's not paid.
That,
And whether it's finance has been moved, madam, Department of Finance.
so that was long time back.
Yeah.
And then, and why you are not reading the entire thing?
It's the award.
See the next line. The ceiling had expired, so you are not in a position to pay.
My lords.
Then-
So, since my lord is also, I indicated that ceiling and expired, so finance department needs to be informed. As regards that, my lord,
No, that was long time back when the writ petition was filed. This was writ petition is of 2020. Does it take another 3 years thereafter?
PhD will kill all the small scale industries in the state, everywhere that it happens. I have a number of cases.
The PHC is,
some other matters, my lord,
PHC is different.
some other matters.
But one thing today I could get that the government is not interested in evicting from government lands. Yes, tell me.
4 weeks should be constraining, my lord. My lord, admitted part, that the component will be.
MSME is different.
Yes, that is right.
For that, she is going for the interest before that.
If it's assessment.
Because his only objection is there.
It's only a-
So you go there for the interest.
Again, another consideration also.
Huh?
Another consideration. After go again, okay, let it pay them, let it come before the court. I'll convince a lot.
At the end of the day, if this court holds that it is an award in view of section 5, this court dare not touch it, then what do? You lose the 28 lakhs also from here. That is what I was saying.
15 lakhs we are willing to pay, my lord, since it's admitted, my lord, what I'm asking for is just a single pay, my lord, to give some more time than 4 weeks.
Okay, 4 weeks, 1 day.
I'll leave it to the she has handled them.
No, there's no, this can't go on like this. These are MSMEs. There's an act out there. You are saying that it doesn't come under MSME, very well. But the fact that this is an admitted fact about this 28 lakhs.
A principal amount. Interest component. is-
Now, so the question whether she is entitled as per the MSME or not, that can be very well thought of, but having challenged the award. Then if you have not challenged the award, because I remember taking up a similar matter where Mr. P.N. Goswami was appearing, I asked him as to whether he was challenging the award. If it is, on one hand, you are saying that it is an award, you know the consequences what you are saying. Just for the purpose of today, winning the battle, you are losing a big war because of the fact that the moment you are saying it to be an award, you cannot challenge then beyond 34.3. And there is no limitation. So this amount will keep on going because you can't challenge this award now. And it becomes a part. It will have a far-reaching consequences which we are thinking. Instead of this being in the realm out here, it's a different aspect.
So, my lord, the principal component, the 28 lakhs, is admitted or this. Once some time beyond 4 weeks, that's all. There's no
Yes.
second training because finance has been moved. There's not a month of ceiling also.
The instant petition has been filed. Seeking a direction upon the respondents to perform their statutory duty and obligation under the Micro, Small, Medium Enterprise Development Act 2006 and in consequence thereof release the outstanding dues of the petitioner along with interest thereon as per the provisions of the said act. It appears from the repetition, it appears from the pleadings, and more particularly from the additional affidavit filed on 23/1/2023 by the petitioner, wherein the award passed by the Micro and Small Enterprise Facilitation Council dated 19/4/2022 have been enclosed. In the said award, in the said minutes, it has been duly recorded that the PHED, the respondent PHED department, have duly admitted the amount of rupees 28,67,845 to be payable to the petitioner. And it was also mentioned as far back as on 22/2021 that the demand for the same have already been moved and it is with the finance department for issue of sealing. Subsequent thereto on 29/10/2021, the representative of the PHCD submitted a letter before the council wherein it was stated that an amount of rupees 28,80,804 had remained as outstanding and informed the council that earlier validity of the administrative approval had expired. And as such, the concerned division have already been instructed to submit the revalidated proposal to facilitate submission of the fund. Thereupon, the council directed the PHE department, Assam, to make payment within 1 month from the date of issue of the minutes and to inform accordingly if the it was also informed that if the payment is not made accordingly, the council would pass award in the matter. It is further seen that in the 11th meeting held on 19/4/2022, the representatives of the petitioner as well as the representative of the PHE department were present. On 19/4/2022, the representatives of the PCD department remained absent. Under such circumstances, an award was passed directing the chief engineer PHCD Hengrabari, Guwahati, to pay the full and final amount of the principal as well as the interest amount to the petitioner as per section 16 of the MSME Act 2006. The learned counsel appearing on behalf of the PHED department, Mr. D. Gogoi, submits that the petitioner is not entitled to the benefits under the MSME Act 2006. On the ground that the petitioner's registration had expired. Be that as they may, the said award, so passed by the MSME Act and by the MSME, by the Micro and Small Enterprise Facilitation Council, have not been put to challenge by the responding PHED department. It is also not seen that the petition, that the PHED department, the respondent PHED had also challenged the jurisdiction of the Micro and Small Enterprise Facilitation Council to take up the matter at any point. Rather, it was the case of the PhD, respondent PhD, that they are going to make the payment, and on account of certain sealing or administrative approval, the same payment could not be made. This court shall consider the said aspect of the matter at a later stage. As regards the rights of the petitioner under the MSME Act 2006. However, taking into account that the admission of the respondent PhD department PhD to the amount of rupees 28 lakhs 80,804, it is the opinion of this court that the said amount is required to be an admission and it is the opinion of this court that the said amount is required to be paid to the petitioner. At the earliest. Under such circumstances, this court fixes the matter again on November 22nd, 2023. The Commissioner and Secretary, Government of Assam, the Secretary of the PhD department, is directed to disburse the amount of rupees 28 lakhs 80,804 to the petitioner. Before the next date. List the matter again on 22nd, on 22/11/2023 for further consideration.
36.
The learned counsel appearing on behalf of the petitioner submits that he has filed a reply affidavit today against the affidavit filed with respondent number 2. List the matter after puja vacations. The registry shall bring on record the said affidavit in reply. What interim order?
Eviction letter.
Oh, then we take it. We don't require reply. Yes, tell me. Eviction of what land? Huh? You mean the government is not interested in it. The learned counsel appearing on behalf of the petitioner submits an affidavit in reply has been filed today, and the same is not on record. List the matter after the puja vacations. Interim order passed earlier shall continue till then. Yes, non-payment of dues. Huh?
Yes.
How much?
1 crore 64 lakhs.
1 crore. For lawyers. Yes. Who is appearing? Which department?
NRC.
NRC.
Home and political.
Yes.
Filed an affidavit.
What do they admit?
In the affidavit, they have taken a stand contrary to the record. There is an appointment order
Hmm.
which is available at page number 14 of the registration.
Hmm. What do they say?
The appointment order says in pursuant to order is so and so, you are engaged as standing counsel for state coordinator NRC, and NRC will receive in effect from the date of this order, with 1/2017. You are requested to take action as per order of the Honorable Guwahati High Court and ensure the following is also applicable. So on and so forth. Down below, the fee structure will be applicable as per notification within 7 September.
Whom and political is to pay.
Home and political.
Who is paying for whom and political?
The affidavit filed on 3/5/2023 of it.
Hmm.
They have come up with an absurd standard of it, saying that you are acting as the standing counsel for the state coordinator NRC and not the NRC. So the then state coordinator will pay your fees from his own pocket.
Oh.
That's what they are saying. And in the meantime, what they have done, part of my bill has already been paid.
Oh, you got 50 lakhs.
No, not 50 lakhs, around 24 lakhs.
Well, very
And
good.
the rest, your lordship, they are coming up with this standard.
Hmm?
The rest, your lordship, now regarding the rest of the amount, they have come up with this stamp,
Hmm.
saying that the affidavit, your lordship, of 3/5/2023.
Hmm.
Paragraph 3, your lordship.
Yes, home and political you are. You want to pay? What is your stand? You want to pay? Prior. Where is that? That a matter and engagement of so and so by so and so, the then one and payment of her professional fees thereof was taken up with the legal representation and the views obtained. That the regarding the appointment of the AR as Imam and processing of a bill submitted by Imam for the report of the Imam was appointed as the standing counsel by AR with effect from Imam with on 10/7/19 with effect from 1/2/2017 as he was discharging as a standing counsel since Imam, citing the order dated Imam passed by the Honorable High Court. High Court is directed.
That's what the order says.
Huh?
That's what the order says.
See?
The appointment order.
I could have gone to that extent. Show me that order.
Page 14 of the. Otherwise, the order is also there.
Where is that?
That is the actual A at December 11th.
Yes, page number 11. Therefore, having regard to the above directions, Superintendent of so and so, Superintendent of Election Commission shall take steps to conciliation and standing counsel of government.
Point number 7 at page 4
Huh?
of the High Court.
Having regard to the nature of the registry shall Imam of the Imam whose name shall be reflected in the court list and so and parties to the proceedings. Where?
Pursuant to this order, the
Because the copy was forwarded.
no. Pursuant to this order, the NRC appointed us on 10 July. Now, first they requested us that please appear for the NRC matters and we continue to appear. On 10 July 2019, this passed an order saying that from 1/12/2017, your services you are appointed.
How? Because the High Court appointed.
So that order does not say that.
So the order on the face of it is wrong.
The order says, you know,
The order never said that the appointing somebody. Only copy was given.
order says that reflect the names of standing councils for the NRC. Now, if the registry is to reflect names for the standing council NRC, there has to be a standing council NRC. So it is.
So are you saying because of that, are you saying that he was the person concerned who has been appointed?
Who was the person? It was pursuant
Can you say that it is this person? Just for example, in that order, my name is appearing. because I was appearing for the Election Commission of India. But I was duly appointed by the Election Commission of India. I had an appointment.
Yes.
But if there was no appointment for the NRC, how can there be an appointment where any order being passed? And are you saying that this court had passed, the division bench had passed that order?
No, no, pursuant to that order was passed by the NRC. That order is in favor of putting it.
That is the order. The order was passed. How can it be given effect from such a particular date? When there is no mention, page number 14 says where? With effect from the month of the order dated 1/12/2017. How?
It says, because you're also.
Because the copy was sub.
No, what happened was, since the registry was directed to reflect the names of Samuel Thompson. So from 1/12/2017 onwards, there was an onus on the NRC to have a standing council. So that is why it's.
Mr. Pathak, this is not a case where this court is going to be doing it. But you may take escape saying that my name is also reflected. And as such, I shall not take it. Still before any other. This court is not going to pass such.
Update.
Yes, oh, that matter.
Yes,
Notice?
feel fine. Feel fine.
Yes, did you get anything?
In this case, I was at few moments. I got them. Whatever I could go to.
When did you hand over to the authorized representative?
Also, here the date is not there, but one signature against an acknowledgement number.
Does it show the date?
Date also is fine.
And it is only the question of date
Yes, but
for which everything changes.
also going by the issuance of the certificate of entitlement date, it appears that on the same day. Also,
How can one say that on the same date it has happened? And who received it?
that
Then,
nothing is only a signature. Is there.
and whose signature? Thank goodness. I have visited the
Going by the sequence
Unit.
of the date.
for physical verification and found the existence of so and so. The dealer had submitted annexures here for grant of certificate of put up for orders. You are referring to this signature?
Yes.
Whose? And no date, nothing is there. So
About that, yes, also the certificate number is there and one acknowledgement number is there. Going by that only, but
acknowledgement of what? Acknowledgement number of 24/6/2014.
and the certificate date is also same. The next is the certificate number.
Where is the acknowledgement number? From where have you got that acknowledgement number?
That losses, they are trying to locate it, but not
Okay.
getting it at, I found only that also.
No, no.
Also, give me for one day, go through the whole record. then-
Chalo. We'll take it up at Tuesday for final disposal. I dispose it at 2. This is the matter has been heard at length. This is the matter on 5th. Final disposal, 5/10/2023 for final disposal at 2 p.m. The records which have been produced by Mr. B. Chaudhary shall be retained by him. Is returned to be produced again on the next stage. Yes, what is this? What is this? So many files. You are the petition. Oh, that hotel.
The hotel is the stop file. We are not running the hotel. It's a guest
Who are
house.
you?
I'm for responder 7.
This
Who
7
is
is,
also At one point of time, the hotel was dark.
you were running the hotel.
Then in order for this code, it was sealed by virtue of.
Yes, Mr. Nayak, you have now allowed them to use as a guest house.
So today morning, from MC authority, they have told me that they have obtained one trade license for running as well. The lordship undertaking was then, distinguished residential and commercial. In all these of the commercial.
And how is it that the GMD has done it?
Definitely at the time of applying for the trade license. The fact that the subject matter is on the litigation law, that fact was definitely.
You find it out from the GMC.
Yes,
You are paying for the GMC and the GMD. Find out.
today morning.
Huh?
The one trade license.
The trade license is there, but trade license did mean that a license has been given to operate in a residential area. So would that a permit?
Otherwise, it is residential building not is permission. Otherwise, permission. But undertaking there is in town. There is a mention that they will not use their property for commercial. They will not use their commercial property. I'm to that point.
No, but that undertaking, unless the GMD does not allow it.
GMT will not.
No. No, you see, my order was very clear.
Property will not be used for any commercial.
Here it is made clear that court has directed for de-sealing of the block, and if there is any transgression to the undertaking. Now let's see the undertaking. Being given to the effect that sealer shall not be used for any other activity other than residential purpose. This court directs the chief executive to de-seal it. It is also directed that taking into account that the expenses or the trade license which have been issued, given to the imam, bearing number shall stand suspended until further orders. If the trade license has been suspended by this court, how can you, the GMC issue?
Trade license for sale was suspended. Now
But without taking the leave, how can the GMC do this?
Yes, sir. They are not aware about this case.
Fully no, you're also.
Now, when there is a direction passed by this court for suspension of the GMD of the trade license, meaning thereby that the GMC knew about it.
But it is really applicable for the case law.
We'll consider that. But how did you issue the trade
Today
license?
morning when I came to know that what trade license, I asked them that what is.
How could this way have been issued? Trade license. And let us see the undertaking that I say that I hereby undertake before this court that I will use the only for residential, and if I let out the so and so to any other person in future, I will not let out the same building for any commercial activity until the GMC of the GMDA allows to use the building for commercial purpose. The commercial purpose has to be given. There has to be a permission by the GMC or GMDA for using it for commercial purpose.
MCA has only given the trade license for running a law. So far as use of the building is concerned,
That has to be changed.
yes, the class has to be same.
Without changing that, how can they give it?
For
And the-
laws, they have for laws, residential buildings have permission. To run a law store. One can run a law from a residential building. That is permission. But only what that commercial.
Means a lot of any size.
No, it's 10 and 15 rooms
How many rooms they are having?
that time.
Yes, how many rooms?
Well, it's a, it's only permissible. 16 beds to 13 beds were like. In my 185.
Of,
185
of,
of the ethics opposition. We filed for behalf of response for them. Kindly see my note at 185.
when did you file it?
185. We filed on 8/9/2023.
179.
185.
The GMC granted license to me to operate a guest house having 60 to 30 beds.
But down below, like we see, thereafter, after 1 as per the GMC Act and rules, bylaws, the license valid. Any of provision of GMC bylaw, then the GMC right, so and so.
No, that is a different thing. When this, can you say having 16 to 30 beds would come within the ambit of a residential? A lodge? Let's see the residential thing. In the GMC Act, I think it will be there, or we will call the commission. This is not there. Whatever he has done, he is in doing it in violation of this court order. And then who has given the undertaking? You. Who has given the undertaking? No. The person who was the owner of the land giving. He is only a lessee.
Yes.
Who is the owner of the land? The owner of the land has given. Huh? The owner of the land had given, if I remember correctly. Nirupama Rava. Yes. I hereby undertake before this court that I will use the building only for residential purpose, and if I let out the building in Block C to any other person in future, I will not let out the same building for any kind of commercial activity until the GMDA or the GMC allows the the building for commercial purpose. This is the undertaking. Who is appearing for response number 5? Response number 9? None. But you acquired the right on the basis of response number 9. So anything happens to you are also responsible. And you filed an application for the purpose of vacating that order only because from the ceiling that you are only using it for the purpose of marriage.
No, that's only, but that has been stopped, because that was used for the purpose of hotel.
No.
Commercial purpose.
No, Mr. Das.
Guest house.
You have entered into the scene later on. You may not be aware. There was no, I passed an order of sealing. It was sealed.
Yes.
Then at that point of time, Mr. Sahewala was appearing. Mr. Sahewala had filed an application. Your client had filed an application before this court that you see there is a marriage in the family, kindly deseal it only for the purpose of marriage.
No, that's
And
so
it is under such circumstances, desealing was permitted, provided it shall not be used in any manner to that effect.
No, but that's I'm aware of. That's I'm aware of it.
Then
It was sealed by virtue of this court order. We made an application for marriage of the son. So accordingly, your lordship allowed
Then?
for a limited purpose.
Yes, then,
Thereafter, we stopped, my lord. It is not for the purpose of running of a hotel, my lord. That is stopped. We complied with the court's order. That is stopped, my lord.
let us see the use of zones. Where will you get it? Residential zone and where? What is permissible? I think that will be there in the master plan. No, residential use. Residential use will be there in the building bylaws.
People working with bylaws.
Show me where it is permissible as per the lodge. A lodge is permissible.
I have just seen
Hmm.
that the bylaws, I will kindly see, that is 28. It says The mixed use building.
No, the building is only purpose allowed is for residential use. Now, in a building of residential use, can you have a lodge? Show me that.
We can, my lord.
Show me.
Can I just show here.
Huh?
Visual not fire.
Where?
My knowledge is from a resident.
No, if it is not permissible, you have to stop because this would otherwise amount to a violation of the sports order. And an undertaking for the sealing will direct the GMD to seal it again. This is a violation.
Try to go before your lordship.
At your cost. No, Mr. Das, you show me. Where is it permissible? The laws is permissible. Else I am sealing it.
My lord, kindly see. Mixed use building, my lord.
Man, we are not concerned with mixed use. It's a pure and simple residential use because that was not changed. The reason why I have mentioned out that until a change is being affected by the GMC means the use of the building has to be changed. And for that, you can very well make a revised plan, ask the change of the building, which he had filed some application, which is now pending. I asked him, then he withdrew and asking him to file a writ.
Exposure, permission. But the permission was granted to me now. I can't get the permission anymore because of thing number C. There are 3 units here. That unit has gone back to the owner. So whatever has to be complied by the owner and he has to apply. Because right, that right is taken away. So your lordship, so the last of the witness said that this item will not be allowed, it was disposed of in terms of
Right.
unit. My hands are tied because I can't apply for it. It's for the owner to apply for it. This-
You are the builder. The owner is not here.
No, it is not.
Owner is not here. So unless the owner comes in, nothing can be done. Because here it was specifically what is being done out here by the GMC and the what you call the respondent number 7 is being hide and seek with the sport. When this court made it very clear, respondent number 7 comes before this court. Look here, I am having my son's marriage, so allow me, I'll deseal it. I'm only going to use it for the marriage. Thereafter, what is this? Okay, now. It appears from a repetition. It appears from an affidavit in opposition filed by respondent number 7 that in spite of the orders passed by this court on on 18/11/2022. Whereby the trade license which was issued in favor of the respondent number 7 and 8 by the GMC was suspended until further orders. taking into account the orders passed by this court. So taking into account, it appears from a perusal of the orders passed by this court. Dated 9/11/2022. And (18/11/2022), whereby this court had categorically observed that a building that is Block C cannot be used for commercial activity of any kind whatsoever till the JMD/GMC permits the conversion subject to the provisions of the Guwahati Municipal Corporation Act 1971, Guwahati Metropolitan Development Authority Act 1985, and the bylaws framed therein under, and the further direction that a trade license which was issued to the respondent number 7 and 8 by the GMC dated 27/12/2021 be suspended until further orders. The GMC authorities, most strangely, during the pendency of the instant petition and the currency of the orders passed above mentioned, have issued a trade license to the respondent number 7 for carrying out the business of guest house having 16 bed to 30 bed bracket air conditioned establishment This aspect of the matter could be seen from the affidavit in opposition filed by the respondent number 7 on 8/9/2023. Taking into account the above, this court could seek for an explanation from the Commissioner GMC as to whether the issuance of the trade license to the respondent number 7, in spite of the orders passed by this court, would amount to violation of the orders passed by this court. Accordingly, list the matter on 10th of October 2023. The affidavit be filed by 6th of October 2023. I've asked them to file the affidavit by 6th. 6th you file.
Your lordship order was, I've seen that order, the building, block C cannot be used for commercial. That's correct. So I was using that hotel, which are residential block, which are used for commercial. So lordship said that you cannot use for commercial. So my lord, in the workshop before it was sealed. Thereafter, I came to the application that please do allow me for 1 day for marriage. So your lordship allowed. So it was desealed. So again, it was closed. Now your lordship query.
I gave the liberty to everybody that you want, let the GMC or GMD take a call to convert it. But without doing it, what are you doing now?
The question is, your lordship, question that how a GMC is allowing for a guest house also for running a restaurant.
And that we mentioning the word business type.
Whether now the question will be, but I am the beneficiary, they have to give a reply. That's why your lordship was directed them. Why not? What I understand that this is in a commercial place I cannot. But if it is a residential, whether they can allow only in a residential. In a commercial minor, your lordship said you cannot do it. This is a residential.
No, no, no,
Where
no,
I'm
no,
using it
no,
for
no, no,
commercial
no.
purpose.
No, you see, the thing is like this. The permission which was granted for block A, block B and block C was only for residential.
Correct, right, that's
The
right.
use was only residential.
Correct, right.
If the use of it was only residential without changing, I have permitted, let the GMC or GMD convert it into
Right.
commercial, do whatever you like. That is your prerogative. I have nothing to say. But until you do it, you cannot use the commercial use of that building.
So your lordship is saying that using the guest house will be commercial, which you cannot do it. That's what your lordship.
I'm only asking for an explanation as to whether it would amount to a contempt. Let him say that it is not so. We'll take it up.
Yes. But, okay, review. Given an order for supply of 1,358 cartons in the month of July 2019. Thereafter, we supplied, there was some shortfall that we are rectified. That year lordship can be see page by the page 25. And accordingly, all the cartons were distributed in the relief camp by the authorities. May I just read page 25?
What is the inquiry report?
Nothing is there, there is no inquiry.
There is an inquiry report. A copy of the inquiry report has been enclosed by the respondent affidavit in opposition file will respond number 2.
Yes, that is there.
What does it say?
It doesn't take into consideration that the supply has been made.
Doesn't take into consideration or negative your consideration.
People distributed were much smaller inside and of poor quality, which created strong resentment among the flood affected people. This is what you see. But they have already distributed it, and you are watching it.
Now then how can I decide this respect? Tell me, when the inquiry report says that this is the state of affairs, how can this court decide?
So, they did not take into consideration case 25.
Understood, but this is the inquiry report. But no, Mr. Das, I can only pass an order for them to verify and pay. Nothing more than that. Now, no, but that would have no meaning because of the fact that unless I say that the inquiry report is wrong.
No, because they did not take into consideration the field officials report.
Whatever may be, as of now, this is the inquiry report. They are going to follow this. We will take it on a better day, not today.
What I submit my lord.
The only recourse which I see today is just across the road, the civil courts. Else, let it come after the Puja vacations. Because this, because it will be a meaningless exercise of issuance of a writ for verify and pay, because they would, unless I say that the inquiry report. Because if I don't say, I have no, you are not going to pay.
Only one point. The inquiry report did not take into consideration the report given by the field official. Field official says, my lord, he has rectified and he has submitted.
No, are you asking that they should make a fresh inquiry? And the inquiry report,
Into consideration the field official. Otherwise, why did they distribute it?
that day,
Now they are saying that we cannot take.
I was going through a judgment of the Supreme Court wherein it says when you issue a writ of mandamus, you can't direct somebody to do it in this manner. It's for them to decide how to do it. Unless this court may at best say that particular thing is wrongly done. We can say that. If you want, I can say that, but not the direction thereupon.
Well, dear lordship, say so on the next day, I'll show that they, your lordship, they have ordered me for 1,400 cartons. There was some shortfall.
Understood, but you see, you are going to avail a remedy of extraordinary remedy by which this court is have to take it. Everything has been done in accordance. For you to be given this 7,40,000.
That is their money, but what I suppose.
The moment they deny to that, this court has to hold it that their denial is wrong. How do this court hold?
Only thing that your lordship will direct that they did not take into consideration the field officer report. Otherwise, they should have given me the purple and I would have taken back. They have distributed it and they have said.
Whether they have given it to you or not, whether they have at all distributed or not, these are questions of fact which they are denying in the inquiry report.
Distribution, they have done it. They accepted.
They say that the distribution was stopped. Hmm.
Only one of your lordship can be case where we, for a second. One second, your lordship may just see page. What they have done. This is what she has said is correct. But later it has been rectified.
Who has given this?
Placement by the circle officer.
Circle officer, was he present?
They have accepted the goods, madam.
And who is the person who has given this report?
The report has been given by. Additional deputy commissioner on the first report.
So then,
We have rectified it. On page 25, I'll just read one page, madam. On last 26/7/2019, the supplier Baumann admitted his mistake. On that day, 500 fresh tarpaulin sheets and on so and so, 448 tarpaulin sheets, total 948 were distributed among.
wait, when is this report at page 25?
Page 25 is 17/8/2019.
And thereupon on 6/8/2019, there is a committee formed.
Yes.
Why did that circle officer submit did the circle officer submit the report to this committee?
To the additional deputy commissioner.
Did it submit in respect to this committee which was given
Committee was constituted, I don't know whether this committee was constituted.
on 6/8/2019?
Madam,
And your report is,
this said it is 17/8/2019.
and this report is given on 29/7/2019.
Thank you.
So how could the circle officer override the deputy commissioner?
Not overriding that. He has admitted that the fresh tarpaulin has been.
Has the circle officer said that the deputy commissioner was incorrect in giving the report?
No, that we cannot say.
Then under such circumstances, whom should we believe, the deputy commissioner or the circle officer?
Hello, dear lordship.
And how could they take into consideration when the report was given on 29/7?
Hello, dear lordship, will kindly call for the report. Hello, dear lordship.
For what?
Otherwise.
No. This is not a matter for calling for records. Records calling is the important matter. We'll have it after vacation. When do you want? We will finish it on the next date. 14th of December, let the weather cool down.
Two reports were there, two reports not given.
Mr. Das, let the weather cool down.
Hold on.
Let them list the matter on 14th of December 2023, on which date an attempt shall be made to dispose of the petition.
Everyone.
Yes.
Yes,
88. Huh? What is the matter about?
But it is regarding ceiling of the sweet shop. Sweet shop,
What shop?
sweet shop.
They have sealed it.
That's it.
You gotta stay.
No,
But you are not running
I'm not running.
for the last 2 years.
For last 3 years.
My goodness.
And they will be under the security
And it's a sweet shop.
sweet shop.
What happened to all your people? The people who make the sweets, they must have left. So what does the ceiling or no ceiling have any makes a difference now? What are you going to do with the room?
Any other purpose, but they have seen under the city and tender side.
So you are going now doing some other business.
No, nothing has been.
You don't have that the people, the curriculum or what you made, the people who make it.
They are the themselves are the halwa.
The halwai. Do you have the halwai? No, they've left.
No,
3 years are they going to wait for you? Hello, we will we'll dispose it of on this the matter on 12th of October, on which date an attempt shall be made to dispose of the petition, taking into account the urgency shown by Mr. Aid Hort, the learned counsel for the petition.
That building is already collapsed.
We'll see. Building is not there.
From 8th of August, I have filed the affidavit showing.
We have taken a photograph.
Chalo. Yes, what is this?
Madam, yes, I have to say,
Ah.
it was filed on the second.
Hmm,
My parents picked up some other.
okay. The Mr. B. Goswami, the learned edition. First week of October. Why? What is the urgency? What is the matter about?
They claim compensation for our names required.
The scheme implemented by reviewing the strengthening of the environment. Oh, that one where you are saying that it is not inside. It was not required. That is your case. And has he filed a reply?
No.
You're not going to file a reply. He has strongly refuted that there has been any acquisition of your land. You have refuted. You say that for the purpose of making that construction, it was not required for acquiring the land. Then if you don't file, Mr. Raman, understood, but if you don't file a reply, you take your own. Okay, release the matter. Not possible. First week of October, how is it possible? First week is next week. We can have it in the second week of November. List the matter on 9th of November 2023. The petitioner, in the meantime, would be at liberty to file their reply by 7th of November. An attempt shall be made to dispose of the petition on the next date.
Supplementary case, number 59 for addition.
Yes,
The matter where the petitioner's tea garden has been attached with the hotel. So a question that followed from your honor, whether the payments have been made or not, the dues have been cleared. I've been instructed that the dues have been cleared. I believe an affidavit has also been filed by the department. Model number 3 in the system.
yes, no, Mr. Das, on the last occasion, you produced one document. And I asked you as to whether these are pending, the petition was prior to that. Isn't this the case?
No, madam, these are,
Yes, yes, this is the case.
That has been deposited by the receiver, not by the petitioner, madam.
Huh?
That amount is deposited by the receiver, madam.
Oh, now the receiver is looking into it.
Not that they are given an order, madam.
Then what do you want?
The tea garden is being run by, was being run by the respondent. The situation that has arisen is that the tea garden was in some trouble. Then around 2015, the old management wanted to sell the property to the new management. And the new management at the time signed a bond a bond was given to the PC on the basis on which the transfer was allowed. And in that bond, it was said that the new management will be given 60 installments to pay off all the dues that were there. So we had up to 2020. It's on record, the bond. Your Honor. And subsequently, it is on that basis that the DC allows the permission for the transfer to take place. And it is in this context that when the dues came, then in the middle, what happened was the DC held a meeting. There's another petition pending for that. DC held a meeting without the petitioners being present, where they took over the management as per the minutes of the meeting. There are two points in the minutes of the meeting that were there. And that's how the management.
Have you paid the amount?
The response.
The long and short story is, during the time when you were running, did you pay the amount which you had to pay? Because this amount is not only your contribution. The contribution of the employer, employees have also been taken into account. So isn't this a case of fraud being committed by you? Isn't it?
No. Your Honor, allow me to submit one document.
No,
This is
what
the-
document?
This is the document.
If you have to submit a document, file an affidavit.
But what I'm submitting is that the dues that were due from to the PF department, that has been cleared by the managing committee. That is correct. There's no shying away from that fact. And we are also challenging the fact that the management was taken over wrong. So now I'm not in possession of the management of the tea garden, nor am I in possession of the physical tea garden. So I'm actually out on the street as far as I'm concerned. And it is by running this tea garden that itself, which is my tea garden, that the dues have been cleared.
But you have taken those money. Forget about your contribution, the contribution from the employees.
That case was filed, a criminal case was filed, Your Honor, against. the
That is a criminal case is different. But about what is about the other thing, the dues? Are you going to say that no, let me go to jail, I'll be happy enough.
No,
Be there in the jail for 6 or 8 months and thereafter I'll come back and free. I don't have to pay.
the dues have
And
been-
my reputation in the meantime will be pending and Mr. Das will be very well taken care of when I'm inside the jail. Then, isn't it?
No, that is not the case.
No, that is the case.
Because the department itself has said that there is nothing due against the ex-management. So it may also be appreciated, two factors were there. Number one is the fact that.
You have sold are you selling it?
No, actually, we are getting into another.
Okay,
Your
sell
Honor,
it.
may allow me to show certain documents.
Sell the garden, get the money, put it to auction sale.
The Honor may please permit me some time, some documents and record, and also make some submission to show why this attachment itself is wrong. That's the first. part.
What is wrong? You have not paid. Merely on the basis that there is a criminal case pending, you should be happy with it.
No, first, there was a time period given to me to pay.
Where about the time period? As per the act, you are to pay the moment you get the amount. You are, what, do you know how the payment is made?
It will be made,
No. You pay the employer salary and from there you deduct a particular amount. And from your side, you put a particular amount and you pay. So you are taking a part of the salary and putting it in your pocket. Forget about your contribution. The employee's contribution is you are putting it in the pocket. And now you want to show. How 226 will be maintainable? A person who has come before this court has to come up with clean hands, with a clean heart.
absolutely.
The heart seems to be not clean.
No, Your Honor, may permit me to show otherwise. So I am the new manager. I want to stress on that fact because
You are the new manager?
new manager, this tea garden was in some distress. That is nobody is disputing that. The tea garden was in a certain state of distress. In fact, I believe the manager had also been salted and that there were labor issues. That is a fact.
So you have taken it up,
I had taken it up.
but you have taken it with liabilities.
I had taken it up.
No,
But
matter over.
the two factors here. Number one. is
For
the
that,
bond.
you may escape from the criminal liability, not the civil one.
Your Honor, may permit me to show the bond that I have signed because I am retiring of that.
The bonds, no bonds doesn't appear. You have not made the payment, that is enough.
So it is on the basis of the bond. that I
Okay,
have
okay.
signed.
How much time will it take for you to sell the property? Yeah, newspaper now. Okay, let us have it in 22nd of November.
And Your Honor, may give me liberty to file that affidavit with additional documents.
File whatever you like. list the matter again on 22nd of November 2023, on which date Mr. N.C. Das, the learned counsel, senior counsel appearing for the respondents, shall apprise this court what are the formalities required for creation of third-party interest. I know that. I know that.
Attachment order was passed on the
No, Mr. Das, I know that what is there. I'm just giving him the time. List the matter next week. It is made clear that if none is represented, petitioner is not represented, the petition shall be dismissed for non-prosecution.
61.
Where's Mr. Mahmood?
If we saw element in our names, I don't know, we have to finish the time. Then my lord, if some unstake from one way for development of the market.
Okay, Mr. Mahmood, we'll take it after vacation. What is the urgent is there?
And now the construction works have been completed, but they are not issuing the allotment to us. So we are
Not issuing what?
allotment of the buildings in the.
Or
budget.
BTs? Not giving it to you.
Not yet given. That is the problem.
Have they given it to somebody else?
No, that is not. The thing is, this they may go through it. And since 2004, I am in that city and it was also written in my name.
Okay.
I have been paying the taxes regularly to the government as required. Now,
Okay.
for the sake of development.
Now we will take it after vacation. This is the matter next,
We
after
can
vacation.
tell us it further.
This is the matter after the Puja vacations on 6th of December 2023.
Status present today.
Huh?
Status present today.
Nobody gave you a status for all this while from 2021 and I am to give you.
Now, like what is completed, that is right.
Okay, file an application for that. We pass an order because how all of a sudden I will pass order.
There is permanent settlement and as the Anchalik Panchayat can only settle it for one Panchayat year. The 1st of July of every year to the 30th of June the next year. He is seeking permanency as a vested right. We can only settle it as per the Panchayat financial rules by sealed tender.
I understand that. So
Then.
that day I passed an order
I
on
don't
municipal.
get it.
court.
I have so many documents.
Okay, we'll take next.
45 corner.
Yeah, is it? Service is complete? Okay, service being complete leaves the matter for admission. Huh? Understood, but it won't be proper now to take it up.
Because I want that the report has been submitted.
So called as to White's report should not be sent to the commissioner, secretary to government of Iman as per the letter dated Iman, and direction be issued to the respondent, particularly the deputy commissioner, to send the report.
That report has been filed.
Now, we have filed the evidence that report has been sent.
You have sent.
So, how do you take it to account and proceed? That's ordinary, order.
So you have sent the report, so nothing remains.
Yes.
Because nowadays, this order I can't pass. What you are asking, because of the fact that this department is not there. This department has now become either social justice or something. What is it? One will be social justice and empowerment, and the other is tribal affairs. So these were the two reports now. This director is no there, the commission, this department is no longer there. So it has to be sent to somebody.
social procedure, that what classes.
We will do one thing. The service being complete, list the matter again on 9th of October 2023. On with at the admission for admission. On the next date, Mr. Dinat, the learned counsel, appearing senior government advocate, shall apprise this court as to which department the said report is required to be sent, taking into account that the WPT and BC department is no longer, has been abolished and has been bifurcated into two departments. That is the Social Justice and Empowerment Department and the Hills Tribal Affairs Department. Huh? Let him get the instruction, because this is your prayer. This prayer I can't allow. So once he says, I can do it.
The report is sent in the month of March.
Just find out. Then you get the instruction as to whether the report has been sent to whom. We can close it there.
46. I am there for application for amendment of the petition. The allotment of land was made in favor of the petition of Party. Then as per the allotment order, 200 plots were on the auction. Out of the petition got one, husband died. He applied for change of transfer of the plot of land in Nashik. That was not done. Ultimately, it was granted in the, he came to know by the deputy commissioner in the year 2014. 2018, we came to know that somebody came and disturbed the land. Then we came to know that it has been allotted to somebody, but we did not get them. So 2018, we filed a petition, and from the ability of the development authority, we came to know it has been allotted in the name of the private estate. So we challenged it by way of amendment. So we challenged that order of amendment in favor of the private estate. Subsequently, we came to know it has been from there, immediately we came to know it has been registered, sale deed has been made into their finger. So we are challenging the registers. So it is all connected. It doesn't change the actual.
But how can you challenge the register sin?
Honorable Justice Surana, because consequences, otherwise if the registered sale is not set aside, so the allotment setting aside of the
So
allotment.
don't you think that it has to be done before the civil court?
Because allotment order, allotment order which was granted to me, was allotted to me. That has been.
But Mr. Does an allotment order confer right?
Yes, we
Where?
have paid the money. All amount has been paid.
Whatever may be, does it confer right as per the Assam Land and Revenue Regulation?
Allotment order on the basis of the auction. Of the, 200 plots of land auction, 200.
You are an auction purchaser.
They are an auction, but
So if it is an auction purchaser, there will be a sale deed.
no, my husband died, so land has to be transferred in the name of the wife for the purpose of registration. Now they are saying that we are not registered. Allotment amount paid, but registration amount we have not done the registration. So because of not doing the registration, we have done it. Now this is a case where my God, on the case of it, total arbitration is on the part of the
Okay, and your objection is on the question of limitation. Whatever may be, your main objection is on the limitation. We say that the amendment is allowed without applying the principle of doctrine of relation back. No matter allows. The instant interlocutory application has been filed seeking amendment of the writ petition. This court have duly perused the application, and more particularly the paragraph number 2 and 3 of the application, wherein the various averments have been mentioned. The amendments which have been sought for in the paragraph 2, 3, and 4, whereby the amendments have been sought for. So, taking into account that the said amendments would be necessary for a proper for determining the real question in controversy between the parties as well as also the amendments would not change the nature and character of the original writ petition. This court allows the instant application seeking amendment of the writ petition, and thereby the amendments sought for at paragraph number 2, 3, and 4 of the amendment in the amendment application be incorporated in the writ petition. This court, however, this court further finds it relevant at this stage to take note of the submission of Mr. UK appearing on behalf of the petition respondents, private respondent, who submits that if the amendments which have been sought for are belated and would revive a cause of action which have already ceased to exist, and revive a cause of action which have already been barred by limitation. Taking into account that the instant proceedings is the instant writ petition, taking into account that the amendments have been allowed in a writ proceedings, wherein the Limitation Act 1963 would not apply. The question of the claims being barred by limitation does not arise. Be that as it may, for balancing the claims of both the parties, this court is of the opinion that if the interest of the justice would be met if the amendment by not applying the principle of relation, the principle of relation back to the amendment filed, the principle of relation back to the amendment sought for by way of the instant application. So this court further keeps this court further keeps the point of the maintainability of the writ petition on the question of delay and laches open. The petitioners is directed to file the amended claim by 27, 14 days will be by 17th of October 2023. Amended writ petition. With above, the instant writ petition stands, instant application stands allowed, and the rate
47-51.
all amendment. What is this amendment business? What are you asking for amendment? What amendment? Huh? No objection? PWD. What is the case file for? You don't know? You want to take time today? Mr. B. Chaudhary appearing on behalf of the PADWD 6 for an accommodation to take instructions in the matter as to whether the respondent department has any objection to the amendment being allowed, the applications being allowed. So list the matter again on 6th of October 2023.
54 to 56.
Yes. Who died? Who died? No. Who died? And this is a contempt case. How can you make them a party? Contempt? How? Contempt for what? So, how are you making? Can there be a contempt against the person who's after his death, his legal representative? Does it flows upon them? Huh? The contempt will be for a permanent injunction or a temporary injunction, isn't it? There must be either a permanent or temporary injunction. You are not ready.
They are the wife and the son of the front member. They stay in the property and the property is in the property.
Is? No, so there has to be some order passed by this court.
It is under Tadu's because in that Tadu's order was passed, again that the contempt petition has been filed. Now the contempt is.
Where? What is that order passed? Which order? Contempt for which?
Contempt case is being filed for the following about.
Which is the order for which it is being done?
But isn't it very-
Unnecessary, these matters are pending unnecessary for all this time. Doesn't require all these things. Contempt should be finished on the first day itself. What do you say, Mr. Mark? First day, no, second day, when the other side appeals. Yes, what is the contempt against which order? 23/5/2011. Yes, 23/5/2011. Directed that the respondent number 4 shall not continue with any construction in respect to the proposed building. Are you saying the respondent number 4 is still constructing? Order is, in view of the above, it is hereby directed that the respondent number 4 shall not continue with any construction in respect of the proposed building. Has the building been constructed or not? So, if it is so, who has constructed? 4 is dead. Can you import contempt against the daughters? Is it possible? Thing is different. No, understood, but the fact that it is only not to construct, the construction has already done. Now, thereupon, it has already been done by a person who is dead. And this court could not. Now you want this court to put their sons and daughters inside the jail. My goodness.
They're not saying that we put it at the neighbor, but they
Are you alleging out here that the sons and daughters had also constructed? Let us put an example upon you or him. He's better off. He has a lot of cases in that manner. It is his father who had made a construction. He doesn't know anything. After the father made the construction, in spite of violating the court's order, he's residing there. There's no order stopping him from residing. Can you hold him in contempt? Or just for example, his father had been involved in some criminal action, can you hold him? No. Because it is no, this cannot happen against him. Yes, if it is a civil liability, you can. And for that, even in matter, therefore I was saying, in a civil proceedings, if it is a temporary injunction or a permanent injunction, then also there has to be the aspect of willful disobedience. And how do you know when they are residing only in the constructed place, unless you get an order? And this 2011 is still pending. My goodness. No matter what any play hidden is going on. Where? You want to make them a party? Chalo. Hmm. Okay, take one allow 2679 we are allowing it. Are we to allow for it? Issue notice. You are appearing for this people? The newly implemented. You are appearing to accept notice on behalf of. Yes, you are there.
Yes, sir.
Tell me how you are initiating contempt against those people.
Yes, sir, because
Now your junior was not in a position to say. Now you are there. The senior has come. So under such circumstances, I think it is better you withdraw.
I had some concept, but still I filed because the content is relating to a building. Like they,
The contempt is not to construct.
Huh.
And the construction was done by the father.
yes,
And they are only residing there.
Yes.
Then how can you have a contempt against them?
yes, sir, I had a
The
doubt.
learned counsel appearing on behalf of the applicant, 2756 contempt submits that they would not like to press the instant application, taking into account that the violation of the order dated 23/5/2011. Order dated 23/5/2011 was that it was only the father, that the predecessor in interest of the opposite parties who have violated the order dated 23/5/2011. Under such circumstances, the instant application stands closed. Now, madam, tell me, contempt, can the contempt proceed against the dead person? In view of the death of so and so, which is an admitted fact, nothing survives in the contempt application, and accordingly, the contempt proceeding stands strong. It cannot allow go to you.
See, I can see.
Which one? 57?
50,
What is 56? 54 to 56, we are not done.
so 56 is, he was the, this was the, attack, but he was so, I don't know, they will have to.
948. Huh? Okay, when did he die? 8/2/2023.
8/6/2023.
Mr. J. Das, appearing on behalf of the petitioner, submits, the learned counsel submits that the petitioner had expired on 8/6/2023, and he would like to take appropriate steps in the matter. List the matter after 3 weeks. কোন মিসকেস এরকম তো এটা ডব্লিউবিসি একটু হয়ে গেল না একটু আছে কি হয় মিসকেস কমপ্লিটিং আবার Yes, 57. What is that matter about?
Inquiries regarding the petition, the petition, I have the responsibility. For the petition, we are clearing some amount from this number, one in the petition. But here in this case, I purchased 3% of
Who
property.
wants the early hearing?
But the central investor security.
You want. You are the respondent number 2.
Who in the petition.
You have filed the application. That the matter needs to be urgently disposed of. Why?
Because the petition has not taken place, we purchased the land on 6/6/2008. We took possession of the land, we have constructed our house.
Why the mutation has not happened?
Because the laws is not coming.
Who?
From Bhartpur, the Bhartpur has to be, the house has to be. Yes, but the house has to be removed, they are not.
Chalo, I এখন allow বল দিব। And then yeah, it is an urgent matter for taking, this is an application for urgent, for taking up the, for early hearing of the accompanying petition. The grounds which have been assigned in the application are justified. Taking into account the writ petition is directed to be listed on 16th of November for final disposal. I allow.